by the Panchayat through a 31-member committee after taking rupees 10,000 per head. It should be settled through tender process. Already there is a existing order passed by your lordship, so it can be taken up tomorrow, my lord.
Motion.
Yes.
Yes. Sure.
Highly obliged.
May I please? Item 17 to 23, you're looking.
Hmm.
The private respondent has filed the affidavit on 31st July, your lordship. So
They
I
have
need-
filed affidavit.
They filed the affidavit, so
Okay.
I need to file the affidavit in reply.
Who was for the private respondent?
Dr. Gauhati.
You inform Mr. Chakraborty?
Yes, yes,
Okay. 17 to
23.
3. N. Upadhyay, learned counsel for the petitioner, submits that the private respondent has filed affidavit in opposition, which is required to be responded, and he accordingly prays for time. Para, in view of the above, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit, full stop, list on the 26th of
20, your lordship.
20,
27 or 28.
20, not 28, 20, yes, 28 of 28 August, 28.
Interim order.
Interim order passed earlier to continue till the next date of listing.
I may be lordship. I beg to mention item number 2, Milord.
Yes.
The matter may be taken fixed on Monday, Milord. Another matter is fixed on Monday. My learned friend.
Two for Forest Department, PHE.
EPS.
What is the other matter?
Other matter fixed on Monday, Milord.
What is the other matter? Number?
Number is Milord.
Supplement 61 to 68, your lordship.
Today is
Yeah,
listed.
today listed, today supplementary list.
No, he put the pen.
That matter is for motion.
Yes, Milord.
The other matter.
Yes. 4043.
Uh,
WBC.
3 A. Ahmed, learned counsel for the petitioners, has requested for listing this matter on Monday, along with another similar matter, WPC
4043.
4043 of 26. 26. Also heard. 3 R. Google and Standing Council, PHE.
PH, your lordship.
Para. Matter is accordingly adjourned to be listed on Monday, date 10th. 10th,
Yes, sir.
10th, along with 4043 of 26. WPC.
May I please, your lordship?
Yes.
Lordship, the concern others, I beg to mention item number 61 to 60 supplementary list.
Yes.
In this matter, we have received the instruction. We like to file an affidavit in all this matter, your lordship.
Hmm?
We like to file an affidavit in opposition on this matter.
This
This
Dekajali matter.
Yes, Dekajali matter.
Like, can it be taken up on Wednesday, your lordship?
When, how soon are you going to file the affidavit?
We will file within this week. On Wednesday, it will be taken up, your lordship.
Okay. 3 R. Gogoi, learned Standing Council, Forest Department has submitted that instructions have been received, based upon which affidavits would be filed, for which he prays for some time. Full stop, para. On request, matters are adjourned to be listed on Friday next,
Very
not
good.
Wednesday. On that will be on 14th, by which time the affidavits in opposition are required to be filed. One order, at Adipa. 20, this will be item number 61 to
61 to 68, your lordship.
61 to 68.
Supplementary.
What about the private respondent, the municipal board? It was supposed to be served.
Yes, Milord. Already, Milord.
You have also taken Dusty
Yes, Milord.
Liberty.
Yes.
Well, you have taken Dusty?
Yes, yes. Milord.
Okay, let us see. Any idea who's anybody is appearing? Okay, please inform him
Very good.
regarding this matter fixed on 14th. Okay, okay.
Obliged.
May I please, Lord, I beg to mention for listing of 2 petition, my lord.
Motion.
No, admission column, my lord.
Admission, why? What matters of which year?
2025, one is 2025, my lord, and another is 2022, madam. Any
22.
20.
25, what is the urgency?
This is, my lord, partition meter, my lord.
Sorry,
So another is payment of bill, my lord.
no, none of those are urgent. 22 will have it.
Okay.
Is a old matter. 22 next Monday.
Obliged, my lord.
Yes.
May I please, your lordship, with the consent of the other side, I'd like to mention item 33 in the daily list today.
33.
Yes, my lord.
Yes.
We have not received instructions on this matter yet. So if my lord can kindly fix it. Within 2 weeks' time, we'll attain the instructions and file an
I
affidavit.
have informed the other side.
Yes,
Yes,
my
your
lordship.
lordship.
Okay. On a request by Sri S. Sharma,
Yes, my lord.
learned counsel appearing for the Forest Department, matter is adjourned by 3 weeks to enable filing and enable him to obtain the instructions / file affidavit in opposition. Full stop. List on 28. 28 তারিখ।
But that is an interim order.
28/8, 28 তারিখ, huh? Interim order passed earlier stands extended till the next date of listing.
Deeply obliged, Your Lordship.
Please, your lordship, with the consent of other side, item number 41. Your lordship, I have to file affidavit 2 weeks time. Yes.
41, okay. On a request made by Sri B. Chaudhary, learned standing counsel, PWD, matter is adjourned by further 2 weeks to enable him to file the affidavit in opposition. Full stop. Para. List on 21st of August, 21/8.
May it please your lordship. Lordship, with consent of the other side, I beg to mention item number 28, lordship.
Hmm.
In this matter, lordship, we have to file affidavit in reply, lordship. And affidavit in reply is prepared, lordship, but the petitioner could not come down to
Okay.
sign it.
How soon
One
can
week,
you?
lordship,
Okay.
1 week.
On a request made by Miss S. B. Sharma,
My lordship.
learned counsel for the petitioner, matter is adjourned by 10 days to enable filing of rejoinder affidavit. Full stop. List on
Friday or
on 14th,
Obliged.
14 August.
obliged, lordship.
May I please, your lordship, with due consent from the other side, I'm seeking adjournment of item number 32. I'm from the respondent side.
Madam Bhattacharya, yes. Okay.
After 3 weeks.
Respondents, which respondents? Sole respondent, madam?
Yes, right.
Okay. Why do you need time?
My senior is out of station actually. The
Who is your senior?
K Das, Mr. K Das.
K. Das. Okay. On a request made on behalf of Sri K. Das, learned counsel for the sole respondent, matter is adjourned to be listed. When?
3 weeks.
Why 3 weeks? Affidavit has been filed.
Yes,
They
yes.
have filed and we will file reply, my
You have also filed.
They have filed affidavit in opposition, Mala. I am for the petitioner.
No, we'll file. Have you filed reply?
Yes, Mala, we are going to file
Okay.
reply, Mala.
Adjourned by matter is কি করলো? To be listed on adjourned by 3 weeks to be listed on 2nd of September, by which time further pleadings are required to be exchanged. 2/9.
Obliged.
Highly
Is there any interim order, madam?
No.
Please. Item number 43, lordship.
Or 3.
I'm for the petitioners, madam.
Okay. On a request made by Miss L. Devi, learned counsel appearing for the ED, 3 weeks time, further time is granted to enable filing of affidavit in opposition. Full stop. List on 28/8.
There is an interim order.
Interim order passed earlier stands extended till the next date of listing. First week of September. Okay, we can have it on 2nd of September. 28/8, 2/9.
May I
Yes, Madam
please,
Sharma.
lordship, I have made a mistake, lordship. There is an interim order, lordship.
Item number,
In item number 28.
have we fixed the date?
Yes, lordship, on 14th.
Interim order. Okay.
Deeply obliged.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 14, lordship.
1/4.
1 4.
Yes.
Lordship, I am for the respondent, lordship.
Your lordship, I am for the petitioner.
Lordship, in this case, we are bringing some time to file our affidavit in opposition, lordship. Lordship, in the
Yeah,
last,
for whom?
I am for the respondent, lordship.
Respondent, which respondent? CGC?
CGC, lord.
On behalf of Mr. S.S. Roy.
Lordship,
24 matter, you have not filed affidavit. Why?
lordship, in this case, lordship, petitioner additional affidavit also not yet filed, lordship.
We were directed to file the additional affidavit, but your lordship, the affidavit is not been signed. So we are awaiting the signed affidavit.
Okay. So it will be a joint request for
Yes, Your
exchange of further
Lordship.
pleadings. On a joint request made by the learned counsel for the parties, matter is adjourned by 2 weeks to enable
Your lordship,
Exchange.
3 weeks time may be granted.
24 matter, by 3 weeks to enable exchange of further pleadings. Full stop. List on 26th of August, 26/8.
Obliged,
Obliged,
Your
lordship.
Yes, miss. Yes, Mr. Sharma,
Item 40, my lord,
40.
40. I appear for the petitioner, my lord, but I've been requested by Mr. M. Smith, who appears for the ESIC. He has some difficulty today, my lord, to seek an accommodation for 2 weeks, my lord. He's yet to file his affidavit, my lord.
You are making a request on behalf of your colleague.
My lord.
Okay.
M. Smith, my lord.
Okay.
He's requested date after 2 weeks or 19, subject to your lordship.
Okay. On a request made on behalf of Sri M. Smith, Learned Standing Council, ESIC,
My lord.
matter is adjourned by 3 weeks to enable filing of affidavit in opposition.
Opposition, my lord.
Full stop. List on 26th of August.
My lord. And there is a stay operating, my lord.
26th of August. The interim order passed earlier stands extended till the next date of listing. Para. Sri M. Sharma, Learned Counsel for the petitioner is
My
present.
lord.
Lordship,
Yes.
at the concept on the other side, I beg to mention item number 37, Your Lordship.
37, yes.
Lordship, I'm praying for some accommodation on behalf of Counsel Mr. D. Gauhati. He has some personal difficulties to proceed with the matter today, Your Lordship. The matter may be adjourned for the day, Your Lordship.
Monday we'll have.
Lordship,
Okay. On a request, have you informed the Public Works Department?
we have informed others, sir.
On a request made on behalf of Sri D. Gogoi, matter is adjourned to be listed on 10th of August.
Lordship.
May I please, your
Yes.
lordship? My lord, I beg to mention for listing of a fresh case, lordship, on tomorrow, day after tomorrow.
Whenever.
Tomorrow,
Not tomorrow, day after,
Day.
Friday.
obliged.
Is it very urgent?
Very urgent, lord.
What is the urgency?
Because lordship, the petitioner herein is a Gau Panchayat lordship, who does not have any permanent office building lordship. Initially, they were allowed to function from some khas land lordship.
What is the urgency?
But urgency is that now they are, authorities are trying to remove the lordship, office building lordship. So they have not available the lordship, office building lordship to function lordship under lordship. Because initially they were
And
allowed.
who are you?
So
Who are you?
I am the Gau Panchayat lordship. Gau Panchayat filed
Panchayat has filed.
Yes,
Okay.
lordship, Panchayat.
Okay, we can have it tomorrow.
tomorrow. Obliged.
My lord, I beg to mention item 48, lordship.
You still have the time. Just sneak of time.
Sorry.
Yes,
need-
item number
48, lordship. I
Four.
need 2 weeks time, lordship, because government may be chance for lordship. I should take instruction, lordship.
for taking instructions.
Lordship.
Okay. On a request made by Sri K. A. Mazumdar, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable him to seek instructions if there is any change in the incumbents
Lordship.
added as respondents. List on, we give a date, list on 2 weeks, 21st of August,
21st of
21st.
lordship, please.
Item kiman polo?
Item 1.
Please, your lordship. This has been filed for making false undertaking before this honorable court. Now, that's reflected in the order dated 13/10/2025, which starts at page 9. The effective portion, your lordship will find at page 11. Now, what has happened is I filed a writ petition for payment of contractual dues, my lord. Now, the respondent appeared. The council made a submission on behalf of the executive engineer, irrigation department, and a written instruction was produced in which it was stated that an amount of 2,49,000 odd amount was released to me. Now, my lord, I disputed that on that particular date. On that particular undertaking, your lordship will see at para 9. Since it's the specific stand of the respondent authorities that the petitioner has been paid his dues for the work executed by him, this court does not find any issue remaining for adjudication in the matter. Accordingly, this writ petition is disposed of by recording the submission of the counsel for the respondents that a relief sought for by the petition has been granted, since the submission has been made on the basis of written instruction issued by the respondent authorities. I disputed that, my lord, and that I have not received. That is stated at para 8. Now, later on also, I approached them after this judgment.
No, you did not dispute. You did not have instructions.
Yes, I did not have
But nonetheless, a statement was made based on which?
a written instruction, not affidavit, my lord.
SPHE, who appears normally?
Now, this is irrigation.
Irrigation, who appears normally?
Mr. Anand Upadhyay appeared.
And Upadhyay. No, here Upadhyay was there.
Yes.
Okay. Heard Sri P. Bharadwaj, learned counsel for the petitioner, who by means of this application has made a complaint regarding an order dated 13/10/2025 passed in WPC so and so, which was this by which the writ petition was disposed of on the basis of written instructions that the contractual dues were released to the petitioner. Full stop. The learned counsel for the petitioner has, however, submitted that an incorrect statement was made in the court on the basis of which the order has been passed, which amounts to disregarding the dignity and majesty of this court. But will it be a contempt?
My lord, section 2B, my lord, it specifically says under civil contempt that breach of an undertaking, my lord.
It was not an undertaking. He said it is made, it's a false statement.
My lord, they produced the written instructions. The affidavit also was not there.
Undertaking is what? That I'll do something.
That I did.
And no, deed is not undertaking. Deed is a statement. It's a false statement. For that, there is another recourse. We are issuing notice at this stage, but if we go very technically, you have another recourse in law, making a false statement in the court. You can take course of 340 or whatever. And that too, false statement by way of written instructions.
Right.
কি করলো last two? The para. Para. While an issue would rise whether the present approach is correct, comma, at this stage, let notice be issued returnable on 2nd of September 2026, established by Speed Post AD.
Publish.
He also makes some
I'll
study what
my lord. Publish.
item number.
Page number 12, question.
This liability statement is by whom? Again, is by executive engineer. This will not be enough. The liability acknowledgement has to be by the chief engineer to entertain a writ petition. Full bench has laid down the guidelines. Work is of which year? 12. In both counts, you are out. We understand RTI reply, but you're in both counts, you're out. That will not do. We cannot go beyond the full bench. We would have issued notice had the response of the chief engineer. But here it's a 2020, 12-14 matter. Will that help? It will not help. You have to approach the civil court. You would have issued notice, just taking the response. But now, a matter of 2014, 12. Sorry, Mr. Borua. You're Borua? R. Borua. Heard Sri R. Borua, learned counsel for the You can withdraw and file a civil suit if you want. R. Barua, learned counsel for the petitioner, as well as Sri Satyajit Datta, learned standing counsel, Revenue Department. And who else?
Water resources there.
Water Resource,
Name is not represented.
for para. The matter pertains to a claim for contractual dues, and in this regard, the learned counsel has relied upon a liability statement obtained under the RTI. Full stop. Sri Datta, the learned standing counsel, has however pointed out that the liability statement is not in accordance with the guidelines laid down by the Honorable Full Bench in the case of Tamsir Ali so-and-so, as the acknowledgement of the liability is not by the chief engineer. Full stop. He has also submitted that the work is of the year 2012. Para. Prima facie, comma, the writ petition on the present subject would not be maintainable, would not be entertainable as per the guidelines of the Honorable Full Bench. Full stop. At this stage, comma, Sri Barua, the learned counsel, submits that he may be allowed to withdraw the writ petition with liberty to approach the appropriate forum. Full stop. Para. Writ petition is accordingly dismissed on withdrawal with liberty as prayed for. Full stop. It is, however, made clear that if any such approach is made, comma, the same has to be considered strictly in accordance with law.
Item 4. Petitioner is an insured person under the rules at IIT. He has undergone the liver transplant operation. It's hospital because he has been referred by the hospitals in Assam. And despite the recommendation by the ethnicity medical officer to the state medical officer for
Yes, what do you say, Mr. Smith?
we have to proceed instruction with it.
Okay. Heard, Sri Aid Heard, learned counsel for the petitioner, who has approached this court for a direction for consideration of reimbursement of his medical bills. Full stop. The petitioner claims to be an insured person under the ESIC scheme and had undergone a liver transplant surgery at the Max Hospital, New Delhi on 14/2/2025, whereupon the administrative officer ESIC scheme had recommended the reimbursement of the amount of rupees 40,55,299 wide letter dated 11/6/2025. First up, as no action has been taken, comma, the instant petition has been filed. But you have a remedy. Don't you have a remedy? Why do you come to a writ court? Let notice be issued, returnable on where did he work?
No, with a protector.
Okay. Okay, returnable on today's 5th, returnable on fourth is a holiday, 7th of September. Labor Department, Miss Udas, State Council 1. And rest, I think you.
No, only 2 and 3, I think.
3 M. Smith, Learned Standing Council ESIC for 2 and 3. And what about Administrative Medical Officer ESIC scheme?
The government can take notice.
Is it?
Yes. This is not on.
4 you examine again 4?
Yes, my lord. I have examined, I have taken the instruction that we cannot scheme. ESI scheme is different. I have taken the instruction.
Okay, 4 again, madam. Okay, 1 and 4, huh?
2 and 3 I can.
2 and 3 Smith, 1 and 4 you does, extra copies. Hey, 2 did you wanna? This is like a 40.
This matter, I had filed a caveat on 3rd. I don't think it has got triggered. So copy was not served upon me.
It was filed on 37.
That's it.
This was filed on 37.
It was registered on, it was registered on 3rd. I have been-
Registration is not important.
because after,
Filing is important.
after registration, they check for.
No,
KVS.
that's okay.
Anyways, Lordship, I'll not.
No, that's okay. But
not
you
objecting
cannot
on that.
find fault with them.
No, I'm not
Yeah.
finding fault.
We
Therefore, I
can
said
have
it
it
should not be
tomorrow.
triggered.
You can give a copy to him.
He can argue the matter because I have seen the petition otherwise.
No, we can have it tomorrow. Have a copy tomorrow or
Yes,
day
yes.
after, whenever you say.
Yes, Lordship.
30 is a 5K. Wait for 5 days. We can wait for one more day. No
Yes,
problem. Mr. He's on caveat. Let him have the copy. We'll have it tomorrow. Then day after tomorrow.
But they
Day
will
after
argue the
tomorrow.
matter, Lordship. It's only an aspect that technically bit is.
So again, after argument, Mr. Sharma will say that I have not seen this aspect. Let it be fair.
Yes,
Let
yes,
it,
yes. No,
day after tomorrow,
Just to
madam.
help both the sides, I was
Yes,
saying this.
Day after tomorrow.
I have no difficulties with that, Lordship.
At the outset, Shri A. Sharma, learned counsel has submitted that he has lodged a caveat
833.
Caveat being caveat number 833 of 2026 in connection with the present order. Full stop. It, however, transpires that this writ petition was filed on 37/2026, whereas the caveat was lodged on 3/8/2026. Be that as it may, and to maintain fairness and transparency, let a copy of the writ petition be served upon Sri Sharma by Sri P. Rahman, learned counsel for the petitioner. Also heard Miss M.D. Bora, learned standing counsel IWT. Para? Let this matter be listed for motion on Friday.
Yes, Your Lordship. Oblige you.
So Laskar, what is this?
Included the final on this final. We could not place our name in the user service portal. And we filed our representation for verifying the.
What is the voter service portal?
The
Your names are not there. Yes, madam.
final electoral group, my name is after some.
Yes, sir.
Lordship, there is a statutory provision for filing of appeal, Your Lordship. So Lordship, no appeal has been preferred prior to approaching this honorable.
Why don't you file the appeal? These are matters which needs verification. In the appellate forum, it will be taken care of. If you don't find any relief, then you come to the court.
We already filed our representation, but next,
Page?
It starts from 88.
88. You have filed representation. Madam, you considered the representation.
Lordship,
This is not before the appellate authority. This is before whom? Election officer. But this needs to be taken care of. This is done when? 28/2/26.
Lordship, the appeal needs to be filed in a proper format, Your Lordship.
You take instructions, file an appeal. Why do you otherwise come to the court? Tomorrow there will be disputed questions of fact. We might again remand it back. You file an appeal. If you are aggrieved, then you come. Okay? Heard Sri H.L. Askar, learned counsel for the petitioner. First of all, also heard Miss S. Kotoki, learned standing counsel, Election Commission of India. Full stop para. The petitioners who are 124 in numbers have projected that they are duly enrolled voters under various polling stations under the 125 Patharkandi Legislative Assembly in the district of Sri Bhumi, and their names were included in the final electoral rolls published on 10/2/2026 2026. Full stop. However, their names were not reflected in the official voter service portal / electoral database. Full stop. The petitioners claim to have submitted separate representations in this regard, which have not been taken into consideration. Para. On the other hand, Ms. Kotoki, the learned standing council, has submitted that the RP Act,
Lordship, 1950,
which section?
Section 24.
The Representation of People's Act 1950 provides for preferring an appeal, and in this regard, she has pressed into service section 24 of the said act. Full stop. Para. Section 24 reads as follows. Para. Can we have a look? Have you read 24, Mr. Laskar?
Yes.
What is it?
Similar order.
Okay. She has also, the learned, for us, the learned standing council has also submitted that similar matters have been disposed of by directing the petitioners, directing the parties to file appeal. Full stop. Para. It is seen that apart from the forum provided by the statute in the form of an appeal, there is a prescription for presenting an appeal, which would require a determination on facts. Full stop. This court is of the view that the remedy provided in the statute is an efficacious alternative remedy, and efficacious remedy which the petitioners would be, in which the grievance of the petitioners can be taken into consideration and resolved in accordance with law. Para. In view of the above, the petition is closed by giving liberty to the petitioners to prefer the appeal in the manner under the provision of law as mentioned above and in accordance with law. Full stop. It is needless to state that if such appeal is preferred in accordance with law, and in the prescribed manner, the same would be considered and disposed of expeditiously and in accordance with law.
Okay.
Three, upor likhiba, SR Mary and Sri SR Borua, London State Council. Expeditiously, when is there any time limit, madam, for disposal?
60 days, Lordship.
The prescription of time as mentioned in the statute be maintained by the appellate authority from the date when the appeals are filed.
Lordship, the appeal practically should be filed within 15 days of the deletion order.
This 15 days is over. When have you come to this court? How many days? This is not deletion. This is a different.
It's deletion.
This is deletion. It is further made clear that as deletion as such has not been communicated, the appellate authority shall not insist on the aspect that the appeal has not been preferred within the time and consider the same on merits. Yes, Mr. Chon.
Trade license applied for should be and issued NOC by respondent to the court, it is the chairman. He is nominated chairman of the Bogatan Municipal Board, he is not issuing NOC. However, the World Commission of Ward number 4, he verified my all report and forwarded to the chairman for issuance of NOC. Only after issuance of NOC, council will can issue trade license. the chairman, my lord, is was my documents and file, my lord, not issue.
No, this is a different shop. You want a trade license for a cloth shop, textile shop. Your grandfather had a trade license for cloth. The other license was for a grocery shop. Rice, oil and flour.
And they paid me the 37.
No, the earlier license in the name of your grandfather.
It was for my-
Oh, so this is a fresh.
Some of the council, my lord, we are there, my lord, we have property.
You have to have with the instructions. Okay. Hertz.
Other particular, my lord, council member, elected member of the council. My lord, was provided.
Heard Sri S. Chauhan, learned counsel for the petitioner, who is aggrieved by the refusal to issue trade license to the petitioner. Full stop. It is contended that the grandfather of the petitioner was himself given a license, a trade license for rice, oil, and flour mill, and the father of the petitioner is also a member of the council. Full stop. Para. Let notice be issued, returnable on today is 5th, on 7th of September 2026. Ms. So-and-so learned standing counsel KAC accepts notice on behalf of respondents, madam?
1 and 3, Raj.
1 and 3. And SDO civil?
I am allowed to work, my lord, service to respond and five by trustee, my lord.
But who is two, Mr. Chauhan? How have you described two? Two.
My lord,
Please read two.
Sergeant, my lord, he is also my lord.
Please read it. What have you written? Officer civil, then director. Please take care in presenting your petitions. You want a director or the subdivision officer? Whom?
Sub-divisional officer.
You don't want a director? Why have you written director? SR Barua for 2 and only 2. Madam, you had said 1 for 1 and 3 and 4 and 5 you will take by speed post. Extra copies 4 and 5 by speed post to AD. Likhi sir, 4 and 5. Additionally, as requested, Dusty, huh? Next date to DD ba. Baki khin sab affidavit se bhej lagbo. Route it through. We have the next date on next date to kuch nahi kiya. You have to file an affidavit in proof of Dusty before the next date. Okay. You serve and file an affidavit. But speed post is also required. Pani anybody, some garam pani, 53. Yes, Mr. Abbas.
Husband established one law
Yes.
in Gauhati, India 2023. And since then, the laws has entered agreement with the company, digital platform company for booking of the rooms, etc. Subsequently, the laws has been, ownership of the laws has been transferred to the petitioner, who is the wife of the alia. He also lordship has the agreement with the oil company lordship for booking of the rooms, etc. Now lordship, on lordship was 7/26 lordship. The chairperson of the municipality.
But don't you think these matters, grievance of this nature, you have to go to a civil court, you have an OYO room, permission not granted by the municipality for OYO.
The dispute is not between the oil lordship, because lordship, the condition lordship, one condition lordship may see. The one NOC has been issued. I have been asked to apply for NOC and I have applied for NOC, and in the NOC lordship, one condition has been issued that I cannot use the loss as a oil loss. That's completely affecting my lordship business, because lordship nowadays most of the bookings have been done under the digital platform lordship. That's why, and since lordship inception 2023 lordship,
Now, how is it followed then other lodges and hotels affiliating under OYO? How does it operate?
In the same area, Lordship, other floors are operating under.
Mr. Talukdar?
Lordship,
take a-
because there was some objection. Perhaps
Yes.
that is the reason. Or anyway, Lordship, this order is passed by the chairperson, Kharupetia Municipal Board. At this stage, notice has to go,
Okay.
Lordship.
Heard Sri J. Abbas, learned counsel for the petitioner, who is aggrieved by imposition of a condition by the Kharupetia Municipal Board for grant of for grant of NOC, whereby the petitioner would be restricted from using the OYO app for running his lodge. Full stop. Para. Let notice be issued. Returnable on 2nd of September 2026. Sorry, Talukdar for R. Talukdar State Council for one.
Others notice will go, Lordship.
What about 4 executive officer? That you can take, I think. 4?
No, notice may go, Lordship.
Even
may
for
have
executive
some-
officer. He's a government servant, isn't he?
Government servant municipal.
Okay, let
In some
notice
cases,
1.
Lordship,
Okay,
there-
2, 3, and 4 by speed post to JD. Steps within 2 working days. Interim. How do you have a mandatory injunction? It will be a mandatory injunction without hearing. Not possible. We'll have their views.
Lordship. Public.
54.
Yes, what is this? Who is your senior? Who is your counsel? Okay, you want adjournment? What is the matter?
Give the instructions, parawise comments.
Let him come then.
Let it be fixed on 20th for admission hearing. Notice may be.
No, notice, he's not there. We'll not like to issue notice. Okay.
My lord.
You place the instructions on the next date, okay? A prayer for adjournment has been made on behalf of Sri T.A. Chaudhary, learned counsel for the petitioner. Full stop. Since this petition was presented on 28/7/2026, Sri N. Borua, learned standing counsel IOC,
My lord.
has submitted that in the meantime he has also obtained instructions. Para. List for motion when?
My lord.
Yes, after
10th.
10th. List on request, list for motion on 12th of August. 12th August.
My lord, can it be on 14th? I'll be out of station.
Okay, 14th. 14th August.
Bye.
By way of statement, we are challenging the cancellation whereby my contract was cancelled. This is the work under MES also.
Work under?
Military engineering services.
But it'll have a arbitrary arbitration clause.
That will come.
How do you overcome that? Who is CGC? CGC. Yes, madam. Whom have you served, Mr. Sharma? Whom have you served? No, who have you served? Okay, you do not know. Who's been allotted? We can have it tomorrow or after some time?
Yes, my lord. After
Okay,
some time.
after some time. Okay, let her have the.
60%.
There's an arbitration clause. On that only we'll like to have your response. Otherwise, issuing notice is not an issue. Okay.
Go to his after.
56.
56. Mr. Chaudhary, for whom?
I'm for the respondent numbers 2, 8, and 9.
2 means? Who is 2?
The Union of India, Ministry of Health and
As a
Family
CGC, as a CGC you are appearing. Yes, Mr. Das?
Swasthya Suraksha Mission, they are the health care provider. There is there are various other schemes are there. MOU relevant is at page 57. Page 57, this is the another part, when your lordship can see, we are the healthcare provider and it shows further various steps to be taken, 64 your lordship can see. Section 6, below, madam. The EHCP will submit claim online in accordance with the process described in so and so. The state healthcare.
You are seeking by the benefit of the scheme.
Yeah, no, madam. We are providing the services. madam.
Understood. And in lieu of that, you are entitled to
Yes.
certain monetary benefits which have been denied to you.
For certain period, your lordship can say. Page,
We have seen 8/5/2023 to 7/1/2024, that period.
that period, it has been shown as rejected by the bank. Your lordship can see 120.
Have you made the bank a party?
Yes.
Which bank?
State Bank of.
State Bank generally appears through somebody or
Normally tell us that they have no authority to reject. But
Okay.
about
Okay.
6, they have
Okay.
given the complaint.
Okay, heard Sri B.D. Das, Learned Senior Counsel, assisted by Sri J. Lotha for the petitioner. Full stop.
There is a provision for
The-
penalty.
Yes, the present petition has been instituted with the grievance that there is a refusal from the respondent bank to make the payments to the petitioners for a particular period 8/5/2023 to 7/1/2024 for the services rendered by the petitioner in terms of the Pradhan Mantri Rashtriya Swastha Suraksha Mission within bracket PM, that's देख लीजिए RSSM.
Amounting to rupees 1 crore 70 lakhs 0.67.
Full stop. The amount involved is 1,70,87,442 along with interest oblique penalty
18 lakh 50.
of rupees 18,55,184 as on 11/6/2026. Full stop. It is submitted that the respondent bank without any reason or authority has rejected the said claim. Para. Let notice be issued.
They have also not taken.
Let notice be issued, returnable.
The dusty also.
Returnable on on 7th of September 2026. Yes, Mr. Gogoi, anything you'd like to say here? Okay. You take the instructions. There may be something we do not know. Sri B. Gogoi, Learned AAG, accepts notice on behalf of respondables 1, 3, and 9, whereas Sri A.K. Chaudhary, Learned CGC, accepts notice on behalf of respondables
2, 8, and 9.
2, 8, and 9. Extra copies. Let steps be taken for service of notice upon the.
It's up to, not poll is there.
No, it is on case to case basis. You have to serve them. Let steps be taken for service of notice upon the respondables remaining jitna hai, by speed post with AD. Steps within 2 working days. Dusty upon
Statement. And other there. TPA के तमाम assist. 1L5 I think.
State Bank is number what?
Some insurance companies are also appearing.
Number 4, you are representing.
No, he's appearing for 3. 4.
State Bank, Dusty will be difficult for you, Mr. Das. State Bank will be difficult with Maharashtra address. It will be difficult for you. Let it go.
Company.
Had it been Gauhati, you would have allowed.
Obliged.
You could have made the Gauhati office party. Who? Past Manager party. Okay, let them come then. Let them come.
55 time.
Dispute Vasil. That's the little
Yeah.
something else. But yes.
Page
Yes.
page number 60, my lord.
Item number?
Page number 59, yes, my lord.
Yes.
Page number 59.
You're aggrieved by cancellation of a contract.
Yes. My lord, unless the both parties agree in writing, shall C, my lord, clause C.
Page
Page 59, my lord.
59.
59, my lord.
Yes.
Unless both parties agreed in writing, such reference shall not take place until after the completion or else completion of the work or termination or determination of the contract under condition 55, 56, and 57 thereof. Provided that in the event of abandonment of the work, cancellation of the contract under condition of 52, 53, 54 thereof, such reference shall not take place until alternative arrangements have been finalized by the government to get the work completed by or through the other contractor or the contractor agency. Here, his termination is under section 54, my lord.
So?
So, my lord, that reference is shall not take place in this case, my lord, for the appointment of arbitrator, my lord, without completion of the work by other contractor, my lord.
Until unless the alternative arrangement has been
Yes, ma'am.
finalized by the government, we cannot go to
Yes, my
arbitration.
lord. Termination for next.
That takes one time.
Yes, my lord.
Okay.
Under clause 42, 53, and 54.
Yes, sir.
In other.
Heard Sri P.K. Sharma, learned counsel for the petitioner who is aggrieved by a termination order dated 4/11/2025, terminating the contract agreement number so and so, relating to provision of so and so, and also the consequential fresh tender process. Full stop. On the aspect of availability of alternative remedy by way of arbitration, the learned counsel has submitted that from the conditions imposed in the agreement, the same would not come in the way of making the present challenge. Para? Let notice be issued, returnable on 11th of September 2026. Madam, for all,
For all, my lord.
Miss Egan, learned CGC, accepts notice on behalf of all the respondents. What is the nature of the work?
Yes, my lord. There is a case one.
Construction of accommodation.
My lord.
New contract has been floated.
Tender has been floated.
Have you, you cannot participate, obviously.
That's
What is the stage?
They extended the last date of.
Okay, let us see.
But several opportunity has been given to him.
Oh,
It was
let us see.
separately filed by me, my lord.
The prayer for interim, have you made a prayer?
No, my lord, not
Okay,
big.
okay. You bring instructions.
Yes, my lord. Master office.
Now, if you are challenging the subsequent contract, if you do not have an interim order, how will your petition survive? No, then you don't challenge then you will be entitled to damage at most, if we find fault with you.
And return of funds.
Yes.
Return, only if you make out a case that there has been some illegality in the decision-making process. Returnable did Diana? Okay.
57.
57, yes, Mitali. Yes.
In terms of, and I think that dated 31/12/2020.
Hmm.
The petitioner participated in the tender process along with further 5 bidders, my lord. And technical bid was open, my lord, on 19/6/2006, page 17.
Yes.
Page 19, my lord, serial number 7. Regarding our ferry service, my lord. Out of 5 bidders, my lord, 2 bidders were found to be defective, 1 withdrawn, and 2 found valid, my lord. And financial bid was opened, my lord, on 23rd of June, my lord, page 31.
It's a one tender, single tender.
After
If none are found to be technically responsive, then they can go for a fresh tender. There is no bar. At least once. That is the CVC guidelines.
In fact, the public procurement rules 2020.
And here, government bill was, my lord, 16 lakhs.
No, that is okay, but you are left with a situation with one tender, valid tender.
Valid tender. And no reason, my lord.
No, no reason means one valid tender is a good enough reason. You may not have a case. Have you participated in the new tender?
No, we will be open on, my lord.
You participate. You would have prejudice to your rights in this. You participate, okay? Heard 3 R. Ali, learned counsel for the petitioner. Full stop. As per the facts projected, in terms of a tender notice dated 31/12/2025, issued by the executive engineer IWT for settlement of the Sarabhog Bohari Alikash ferry service, comma, the petitioner had.
Sontali.
Okay. You did not put all the names.
Sontali Bohari Alikas. Page 33.
Not Sarabhog.
No, Sarvo.
Oh, you read Sarabhog.
Page 33, my lord.
33, yes. How do you spell S-O-N?
Sontali, Sontali.
Sontali. Sontali Bohari's Alikash.
Alikas.
The petitioner, along with others, had submitted his bid, and out of 5 numbers of bidders, two bids, including that of the petitioner, were found to be technically responsive. Full stop. The bid offered by the other bidder, the financial bid offered by the other bidder, was found to be higher than the petitioner. Full stop. However, it was detected that the land documents of the highest bidder was not proper, and accordingly, his bid was held to be non-responsive. Full stop. The petitioner has submitted, the learned counsel has submitted that the petitioner had a legitimate expectation that the settlement would be made by him, as he would be the highest bidder. Full stop. However, by the impugned decision, comma, a retender has been initiated by notice dated 28/7/2026. Full stop. The learned counsel has submitted that such retender is not in accordance with law, and the allotment was liable to be granted to the petitioner, as he was the valid highest bidder. On the other hand, comma, Miss Dr. Miss M.D. Bora, learned standing counsel, Transport Department, has submitted that the situation was of one valid tenderer, in which the procurement rules prescribes for a retender, which has been accordingly done. Full stop. She has also submitted that there are CVC guidelines that at least for one, that at least on one occasion, comma, a fresh process should be initiated in case there is one valid tenderer. Full stop. Para. Be that as it may, comma, let notice be issued. Returnable on the 7th of September 2026. Ms. Bora, the learned standing counsel, accepts notice on behalf of all the respondents that extra copies be served. Para. Sri Ali, the learned counsel, prays for an interim order Full stop. This court is, however, of the view that the action to go for retender cannot be held to be prima facie illegal, as it was a situation where one valid tenderer had existed in the earlier process initiated by tender notice dated 31/12/2025. Full stop. This court accordingly is not inclined to pass any interim order of stay of the fresh process. Full stop. It is, however, provided that if the petitioner participates in the new process, the same will be without prejudice to the rights and claims raised in the present petition. Difficult. Okay, let us see. Okay, in the synopsis, you can make the correction. Synopsis. Yes, give the second copy also. Santoli. 58, Mr. Bothakur.
Here we have now again settlement of a private market, private market. Your lordship will kindly, the order is that page 39. Settlement of Puttimara, this was your lordship, this is 31/2026. First order. He had admitted your lordship. Reference to the subject cited, we are informed that the person to provision of section 1.
It's a private market. You had initiated your committee, and now it has been sought to be settled with respondent by 8.
Your lordship, and that for initially for 6 months, your lordship. And then your lordship, that has elapsed, your lordship. And on page 42, your lordship will find there is an writ petition, your lordship, filed by some other persons. Your lordship. They also claim that they are owner. That's a different matter, your lordship. But the fact remains that they could not have passed this order. And then your lordship will kindly see page 42, in continuation of the decisions earlier taken by the General Standing Committee of Kolkata Zilla Parishad, booking held during the year.
Yes, Mr. Kaur.
Possibly, another petition is
That withdrawn.
Withdrawn.
That since term has been already offered, that they are.
Now that has been extended till 31st of December. You are agreed by that. Earlier petition had come, who had come before this court?
some other party.
Some other part.
They also claim to be the owner.
Yes.
That I have mentioned in my petition.
First, you have to clarify who's the owner.
First,
Who has the locus to espouse?
Ultimately, see, even otherwise also, your lordship, they could not have done it, your
But
lordship.
at whose instance?
Lordship.
At whose instance do we adjudicate this matter?
No, your lordship, we are claiming that, your lordship, we are the committee and we have also annexed the Gamabandi, your lordship. The land is our name, this committee is named.
In the earlier case, was there any interim order passed?
No, your lordship, no interim order was passed. That's the, since that was.
You take instructions, Mr. Kaur?
Yes.
Okay. Heard Sri S. Bothakur, Learned Senior Counsel, assisted by Ms. P. Bora for the petitioners. Full stop. It is contended that the Kusumara Anda Bhanga Machara Bazar, dekh lijiye, in the district of Borpeta is a private market which was established in the year 1979, and the petition number 1 committee was constituted to manage and run the market, which it has been doing. Full stop. However, on 31/2026, an order was issued for settlement of the Kosumara Ananda Machbara Bazar with cattle market with the respondent number 8 for a period of 5 months. Full stop. The Senior Council has also submitted that the said settlement was put to challenge, albeit by another person. Full stop. However, after expiry of the said term, the same has been extended by another period from 10th of July 2026 to 31st of December 2026. Full stop. The Learned Senior Council has questioned the authority and jurisdiction to make such settlement over a private market. Full stop. Let notice be issued returnable on. Are there any private respondents?
Yes.
The settlement folder will make it.
Okay.
Respondent number 8.
Returnable on 7th of September, today's on the 4th is the holiday, 7th of September 2026. Shri K. Kaur, learned. You act as, you appear as
Additional AG also.
additional AG. Accepts notice on behalf of all the respondents.
No, your lordship, accept respondent number 6 and 8. Your lordship.
1, 2, 3, 4, 5,
Yes.
6.
No.
6 revenue, 5 and 5, okay.
Revenue.
5. Extra 5, whereas 3 are Talukdar. Oh, no, revenue. Revenue is there, Satyajit Datta. Whereas 3 Satyajit Datta, learned standing council revenue, except for respondent number 6. Let extra copies be served. Let steps be taken for service of notice upon the respondent number 7 and 8 by speed post to TD. Full stop. 3. Water court, the learned senior council prays for an interim order. Full stop. However, since the period has already commenced, this court is not inclined to consider the interim order at the motion stage, which, however, will be reconsidered on the returnable date. 5 and 6 are
7 and 8, your lordship, I may be allowed this.
okay. 7 and ऊपर dusty भी कर दीजिए, हाँ? Same observation. Next date, and you have to file an affidavit before the next date on dusty.
Obliging.
5 and 6 are Talukdar. State Council. এজন্য লবো কিয় হয় নেকি oh Mr. Mohanto, yes, Mr. Nath is not well. We had fixed these matters today of parted. Okay, we'll have it some other day. He's not well.
He's unwell, Lordship. Just now he informed me.
Yes,
Yes.
okay. Friday or Monday also we can have.
Yes. it's
Let him
only-
have one more day. Monday, next Monday. Provided you are there. Okay. Heard 3 KK Mohanto, learned senior counsel for the petitioner. Full stop. Miss, as well as Miss MD Bora, learned standing counsel transport department. Full stop. Miss Bora has, however, informed that Sri Dinath, learned senior standing senior government advocate, is unwell and has prayed for a little accommodation. Full stop. Para. In the interest of justice, matter is adjourned to be listed on. We'll have it on Monday.
Lordship.
On 10th. We'll have it. That understanding is there. Even today we wanted to have it.
Yes.
We'll have it. Okay. Okay. Stay vacating.
Yes. May I please the lordship? My senior PG Mohanto will approve matter. He is some personal problem today.
Who? TJ Mohanto.
Personal problem today. At any time, as my senior consider. He is not ready to take it.
At any time is a very difficult proposition.
Monday.
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 Okay. What is the matter?
What had happened, a particular lordship knows government has taken a policy decision that they will now shift to mill on e-mode.
For okay. For procurement.
No, this is Kampachat Millard market.
Yes, yes.
Therefore, Millard temporary settlement has been given to the existing lessee by adding 10%. That has been, he's not a tenderer, Millard. Supposing he wins the case, what he gets?
You are not a tenderer.
No.
Tender has not yet been invited.
Government has taken a policy decision, Millard. that-
But in all cases, 105 violation we have said.
No, Millard.
105 and Rule 47.
No, true.
In substance, that is a.
But they're also undergoing training and they're imparting training for the e-mode. It will be done very soon.
That's why.
Now who's running?
Well, Jila Parishad run.
So now Jila Parishad, but there was a settlement order which has been stayed by this order. And the government policy is very clear, because
Okay, we'll have it on Monday.
Monday.
Heard Sri K. N. Chaudhary, Learned Senior Counsel for the applicant. Full stop. Also heard Sri K. Kaur, Learned AAG, appearing for the PNRD department. Full stop. Sri B. Rahman, Learned Counsel for the opposite party writ petitioner, has however prayed for a little accommodation on behalf of Sri T. J. Mohanta, Learned Senior Counsel, leading him. Full stop para. As agreed to by the Learned Counsel for the parties, matter is adjourned to be listed on
Monday.
10th. Interim order passed earlier, stands extended till the next date of listing. Mr. Kaur, you complete the process. Why is litigation unnecessary? You don't need so much of time to give training. 1 day, 2 day training, that's all. Okay.
11. I do 11.
Medical College Authority Lordship purchased some SSI product petitioners lordship. Has 2 orders lordship. In respect of 1 order lordship, this petition is in respect of 1 order lordship. Supply order.
As to how much.
In respect of another supply orders lordship.
You are supposed to have some instructions, Mr. Abbas. Have you got the instructions?
Yes, I have that there are 2 orders, supply orders, and this petition pertains to 1 supply order, and the respondent authority filed affidavit where they admitted for the both supply orders. The total amount due I am entitled to. So lordship, I have filed another. Therefore, I have filed another petition lordship. That is lordship.
Another writ petition.
Not been listed. So
Fresh petition. What about this one? 18 is pending since 18.
yes, this was pending since.
Huh?
Yes, this has been pending since.
So we have to close this. Either we hear this and close this. We cannot afford to keep a 18 matter pending. You are for whom? For ASIDC. You argue the matter, we complete this. We cannot afford a matter of 18 to be pending.
Supply order is a case lordship.
What is it about?
Lordship, I have supplied some SSI product loss, small scale industry product loss.
Petitioner supplied SSI product.
Yes, sir.
To whom?
GMC authority, in persons of the order, supply order.
GMC means Municipal Corporation.
No, no, sir, it's Gauhati College.
Hospital GMCH. Okay. Then thereafter?
Thereafter, lordship.
When was it done?
I have supplied lordship and the bill has.
When was it done? Supply?
Supply lordship of. At bill lordship, 18 lordship, SSC. On 1/3/2016.
1/3/2016. Yes.
Delivery around. Thereafter, lordship, a bill has been prepared on lordship 1/3/2016 on the same date. Page 20.
Yes.
So thereafter, lordship, some amount has been paid to me, lordship.
Thereafter?
After payment of the one portion of the due lordship, a supplementary bill has been raised, prepared lordship at page 21. The supplementary bill, it is reflected that city ASIDC authority has prepared this lordship. There 3,62,618 rupees is outstanding due lordship.
Thereafter?
Thereafter, lordship, we have filed this petition lordship.
This has not been paid.
Not been paid lordship, and we have filed affidavit. The GMC is authority.
GMC has filed affidavit.
In paragraph 7 of the affidavit lordship, the
Paragraph?
Paragraph 7.
Yes,
May I read, Lordship?
please.
That with regard to the statement made in paragraph 8 of the request, the deponent therefore state that it is true that deponent had placed 2 orders. That another orders I have said. Before marketing manager ASIC for supply of goods at office order number so and so dated 21/9.
You are reading paragraph 7, second part.
Second part.
Okay.
First part.
Then that with regard, please read.
With regard to the statement made in paragraph 8 of the petition, the deponent begs to state that it is true that the deponent had placed 2 orders.
No, it is true that a proposal. Where are you reading?
Here the deponent.
No, paragraph 7. You read here. It is true that a proposal of hostel furniture was submitted to the director of. Please read. How is it different? Madam, how is it different? That is why we are asking you to read again.
Also, the deponent begs to state that it is true that deponent had placed 2 orders. No, it's wrong, someone. Typing mistake, I think.
Yes, you see this, Sondan.
It is admitted that 3,62,000 they have already received, Lordship.
Now, how are the copies presented to the court different from the copies you are retaining? Both of you read.
No. Here also, Lordship, with regard to the statement made in paragraph 8 of the petition, the deponent begs to state that it is true that a proposal of.
Yes, where is that one?
The second paragraph, second portion. Again reflected that the further exposure is a deponent submitted to the program.
Oh, it is changed.
But nonetheless, we have to proceed whatever is there. Which part you want to rely, Mr. Abbas?
The 2 orders before Lordship, the deponent had placed 2 orders.
Okay, second part. Okay, before.
Two orders. There's something. I am reading my copy. There's 2 orders before the marketing manager ASIC for supply of goods at office order number so and so dated 21/9/2015 and number so and so dated 21/9/2015, and the deponent submitted sealing demand of rupees 14,59,237 only for purchase of the hostel furniture to the Director of Medical Education Assam by letter number 23 and letter dated 2/3/2016, but out of which the deponent had received an amount of rupees 3,62,000 only for FOC during the year 15/16, and with rupees 10,87,237 only as outstanding. Accordingly, the said amount has been released. Additional 5 data 34,600 the deponent submitted a proposal of DME Assam for revalidation of sanction of
At present, 1087,237 is pending.
out of these 2 works loss.
1087,237 is pending.
Yes, and in the aspect of this lordship petition, only lordship pending 3,62,618.
But that has already been paid.
Lordship, may kindly see the supplementary lordship. Bill lordship at page 21.
They had paid an amount of 3,62,000. And this amount is, this petition is for an amount of 362,318. What is the amount involved in this petition?
3,62,618.
This, madam, you have to pay. These are admitted.
I'll have to obtain instructions, Lordship, because 18 matter after.
Now, if it is not paid, then you have to pay. If it is paid, matter is
Also,
closed.
fix the matter, I will obtain the instruction.
18 matter, we are not adjourning.
Short date, Lordship, short date.
Day after tomorrow. Day after tomorrow. Okay. Heard Sri J. Abbas, Learned Counsel for the petitioner. Also heard Ms. D. Bora, Learned Standing Counsel, Health Department, and Sri A Misra on behalf of 3 S Das on behalf of ASIDC. Full stop para. From the pleadings exchanged, it becomes clear that due to lack of FOC for the particular period, comma, the outstanding, there has been an outstanding of 3,62,318, full stop. Ms. Bora, the Learned Standing Council has however submitted that since the matter is pending since long, comma, up-to-date, updated instructions are required to be taken, full stop. This court is however of the opinion that matter being pending since the year 2018, adjournment cannot be granted, full stop. However, in the interest of justice, a 2 days time is allowed to enable the Learned Standing Council to obtain the instructions regarding the updated status. Para. Matter is accordingly adjourned to be listed on 7th of August. 7th for disposal. We also take instruction, Mr. Abbas, whether amount has been paid in the meantime. Are you in touch with your clients or not? Not paid. Not paid. Then we'll pass a direction for payment.
Yeah. This is for non-release of securities deposit. This pending. I'd like to draw your lordship's attention to an order.
Pleadings exchanged.
Yes.
Pleadings exchanged.
Second.
Yes, sir.
It may kindly peruse order dated 8/12/25 amount. Whereby specific directions that.
Yes.
My lord, in this case, my lord, madam, because of arbitration proceeding, we have withheld the security deposit, but that has already been awarded, my lord. Arbitrator has awarded that proceeding has been over, my lord. I have some instruction that they have filed some appeal, my lord. Kindly fix it after 15th of August, my lord. I will declare that whether
Appeal against what?
against award that is yes.
That does not affect this order, your lordship.
My lord, kindly on after 15th of August, my lord. Take the matter, my lord. I'll clear my stand on, my lord. We have filed our affidavit in opposition also, my lord, page number 73, my lord.
See, madam, you are at liberty to challenge the award.
Yes, my lord.
But this security deposit, is it connected to the award?
Yes, my lord.
It is not connected to the award. You may file an appeal, you may set aside the award.
Yes, my lord.
You cannot withhold the security deposit. How much amount is involved?
75 lakhs.
And see the orders of the court
Yes, my lord. That
on
is there.
8/12.
Yes, my lord. That is there, my lord.
Commercial banking rates should
Yes,
also be imposed upon you
Yes, my lord.
from the date of the award,
Against that, my lord.
23/5/2024.
Yes, my lord. That is, Amar, kindly fix it on immediately after 15th of August, my lord. I'll clear the stand
Are
from the instruction,
Sri
my lord.
A. Biswas, Learned Counsel for the petitioner who has drawn the attention of this court to the order dated 8/12/2025, whereby this court had imposed certain conditions on the aspect of return of the security deposit. Excuse me. It is submitted that the amount is yet to be refunded. On the other hand, Ms. A. Gayan, the Dalit CGC, has submitted that certain steps are being taken
No, my lord,
for
that has been taken or not, my lord. That is, my lord, informed.
Ms. Gayan, the Dalit CGC has submitted that some time may be granted to take the updated instructions,
Yes, my lord.
including the aspect as to whether any appeal has been filed or not.
Yes, my lord.
Has been filed. Up to date instructions, don't say anything, up to date instructions. Para? Matter is adjourned to be listed on, matter is accordingly adjourned to be listed on 17th of August. 17th.
Item 13.
Yes, Mr. Sigdar.
Here in this case, petitioners, they are hailing from Gauhati district and they went.
You filed your reply.
Yeah, we have filed. They went to Nagaland where they got gun license and employed as a security guard in various entrepreneur. They returned back to Gauhati district and applied here for renewal of their gun license.
Yes.
The district deputy commissioner has not considered it. Although the NOS was given by the from police authority of the Nagaland, as well as there was favorable report of the local policeman.
Why do you need gun license?
If they have the gun license, they are getting employment. That is the only thing.
Employment.
Employment. As a security guards, they are employed. I have annex one certificate, but is 64.
Where is the requirement by the employer? Is any such requirement?
That's like yes, that's like big entrepreneurs or jewelry shop, big there needs security guards in car. Bank also. This type of situation, they are employed. They have the gunners.
Their licenses has been issued by the authority of another state, lordship.
Yes.
And they are seeking renewal in our state.
This cannot be matters of right, Mr. Sigdar. We have dismissed petition seeking renewal of gun license.
Moreover, lordship, it seems at the age of when they were minor, they obtained the license. If lordship from their records only, and we have also stated in our affidavit, page 72, lordship, paragraph 5. The main petitioner Kapiluddin Laskar, that license was issued on 15/4/1985, and whereas the date of birth is recorded in the license is 1/2/1975. Similar, likely other two petitioners also.
Okay, we'll come back in 5 minutes. We'll dispose of this petition.
So Lordship, there exists some doubt regarding the age of the petitioner at the time of acquisition of the license, Lordship. All they were minor. And it was issued by the another state authority, Lordship.
And then we have made a specifically line. But the license was originally issued in another person, another person's. And
Another person.
in the name of another person. And when the licensee did not continue, and these people has applied, license has been issued.
Lordship,
Therefore, they find out the other, my findings, contradiction in the entry of the.
How can the license be transferred?
Yes, Lordship.
Can a gun license be transferred to another person?
They cannot.
That was, that was done in the Nagaland.
It's done in Nagaland. We are in Nagaland. That issue is not before us.
That's why we
Where
are
on the
saying
issue?
there is the accused doubt, Lordship.
All they have issued and when we came back to our own state and we applied here for review. There was a report from the Nagaland authority that NOC is given to them. And in the local police also verified no adverse report.
The DC has said, DC has got serious objections.
This is on a wrong finding. Not improper.
Heard. 3. A.R. Sigdar, learned counsel for the petitioners, as well as 3. S.R. Barua, learned state counsel. Full stop. Considering the subject involved in this writ petition, which is pending since the year 2022, and also the fact that pleadings have been exchanged, comma, the petition is taken up for disposal at the admission stage. Full stop. Para.
I should point out one thing, Bernard. There is a recent judgment of the Supreme Court that will maybe in other state may be considered. That is the judgment of law Hussain versus State of Punjab, 2025.
Give the citation.
My lord, it is proper citation is not law of Hussain versus State of.
At least give the name of the parties, the judgment date.
Yes, my lord. Law of Hussain.
Give in a slip of paper.
Yes, we furnish, my lord.
The petitioners, who are 3 in numbers, have joined together challenging the inaction of the deputy commissioner, presently district commissioner Hojai, in not renewing their gun licenses. Full stop. It is contended that the petitioners were earlier employed in private companies in Nagaland and in other places outside Assam. Full stop. It is also contended that because of the expiry of the earlier gun license, comma, the petitioners have been rendered jobless and they hail from the Hojai district. Full stop. Para. 3. Sigdar, the learned counsel for the petitioner, has submitted that the gun license is required for in connection with the nature of the job, and full stop. It is also submitted that they had licenses, gun licenses issued by the government of Nagaland, and NOC has been given by the state government for renewal of license, which have not been taken into consideration. Full stop. He has also relied upon a decision of the Honorable Supreme Court, a decision of the Punjab and Haryana High Court in the case of so-and-so versus so-and-so. Please give in a slip of paper wherein it has been stated that renewal of gun license can be considered by another state. Para. 3. Barua, the learned state council, has however raised serious objection on the writ petition. Full stop. By drawing the attention of this court to the affidavit in opposition filed by the respondent number 2 on 30/6/2025, the learned.
No, Lordship, later affidavit, Lordship.
No, first, let us have this 36/2025, the learned state council has submitted that the deputy commissioner, after exercise of mind, had come to a conclusion that it was not a fit case for renewal of the license. Full stop. Reliance has also been placed on the subsequent affidavit filed by the respondent number 2 on 1/6/2026, wherein the aspect that there are various anomalies in the renewal aspect have been highlighted. Full stop. It is submitted that there are grave doubts regarding the age of the petitioners and also the requirement of such gun license. Full stop para. The aspect of issuance of a gun license or renewal cannot come within the ambit of fundamental rights, and it is merely a legal right which can be placed before the appropriate authorities who would apply their minds. Full stop. The amongst others, comma, the party seeking issuance of a license or renewal thereof would have to make out a case that the same is required for their safety and there is perceptible threat which even after being reported, comma, the state is not in a position to act upon the same. Full stop. Even thereafter, comma, the ultimate discretion has to be exercised by the state. Full stop. In the instant case, comma, the learned counsel for the petitioner has contended that such license, that such renewal is required in relation to the job which they are seeking. Full stop. Para. The aforesaid submission, however, is not acceptable by the court, as no person can, as a matter of right, seek renewal or issuance of a gun license, which ultimately would depend on the subjective satisfaction of the issuing authorities, which will consider all the relevant factors. Full stop. Both the affidavits filed by the respondent number 2, as mentioned above, have stated adequate reasons, including the bona fide of the petitioners. Full stop. The case law relied upon by the petitioner would not come to their aid, as the ultimate discretion is to be exercised by the authorities in accordance with law, which appears to have been done in the instant case. Full stop. This court is of the opinion that no case for interference is made out, and accordingly, the writ petition is dismissed. Reply for what have you stated?
That the license were issued to another person. And
that will go against you, Mr. Sigdar. That will say that Mother Lahiba. Sri Sigdar has clarified that a reply affidavit has been filed in which it has been stated that the licenses issued by the state of government was in the name of some other persons, and the renewal has been sought by the petitioners. Is it possible, Mr. Sigdar?
It was subsequently.
Was issued. Then subsequently they have also reviewed.
Okay, no. Thank you. Next.
They say it.
Please give the citation.
15.
So we'll file an affidavit in this matter. Lordship,
You filed?
we are filing.
Okay, what is the matter about, Mr. Roy?
Installation of the pools, my lord, inside the private land without any permission.
Here for the
My
APDCL.
lord.
How soon can you file the affidavit?
My lord, within a week, my lord.
Within a week.
With
Let him
all-
file. Okay.
my lord.
Heart-free GRO Learned Senior Counsel, assisted by Sri P.K. Munir for the petitioners. Para. Sri K.P. Pathak, Learned Standing Counsel APDCL, however, has informed that the affidavit in opposition would be filed shortly, for which he prays for a week's time. Para. In view of the above, matter is adjourned to enable filing of affidavit in opposition. Full stop. List on, we can have it on 14th. Is it okay? 14th of August. Interim order passed earlier to continue till the next date of listing. What interim order is there?
My lord, can it be on the 19th, my lord, if it's not inconvenient for your lordship?
Okay, right. 19th, okay. 19th, Mr. Roy? 19th.
Deeply.
16.
Yes, madam, 16.
Some veterinary species, fishery university, which has not been reflected yet.
I have filed an IA, not listed today. When have you filed? Let the IA come. What is your name, madam? Ms. P. Roy, Learned Counsel for the petitioner has informed that an IA for implement has been filed on 3/8/2026, which however has not been listed. First of also heard 3 R. Gogoi, Learned Standing Counsel, Assam Agriculture University, Para. Let the aforesaid aspect be verified by the office and the IA be listed. When? Monday? On Monday. Date. Madam Devi, where are you waiting for so long? Senior members waiting for so long, not required. 24. Yours item only. Okay. Oh, very good. Yes, what is it?
Petitioner is the stamp header.
Where?
Stick Nagaon, my lord.
Okay, then. Other side.
That side is not.
Yes, madam, das. Mr. Deka? You are for private respondent.
Yes.
For the stock holding department.
Its cancellation is by you.
Yes, yes.
You have filed affidavit.
Yes, we have filed, madam.
We can take up this matter if you are ready.
I have filed my representation, my lord. That representation I have stated.
First, let us have the facts. How many of you are there? One person.
One person.
You had a license, stamp vending license. When was it issued?
My lord, 29/9/2018.
29/9/18.
And on 26/7/2023, license of the petitioner was updated.
20?
26/7/2023. He updated the license.
Renewed.
Renewed. Through eco and by running the stamp instead.
Thereafter?
Thereafter, my lord,
You're having your stall at Nagaon.
yes. Then, my lord, on 26/5/2025, he lost blank P stamp papers along with some other belongings, my lord.
He lost.
He lost. Then he filed first information report on 9/7/2025 and on 9.
Why so late?
My lord, because I have a reply, my lord, in my reply.
From May to July, why are you waiting to lodge an FIR?
Yes, my lord. That is, I have mentioned in my reply. And then, my lord, on 19/7/2025, my lord, he submitted application before the reopening the account of the petitioner, manager of the Istanbul. So
You
my
filed an application for?
before the manager.
Why? Application?
Holding. That is, four, respondent number 4. My simple player is there, my lord.
Now license has been cancelled.
Cancelled.
By which order?
There is no order, my lord. Nothing, my lord. But he did not allow me to proceed. That is my case, and my simple prayer is to reopen the extent, reopening the license. Is my case. And why I have come delay, my lord, I have mentioned in my reply.
You have an access to the e-mode for procuring the papers. Now that has been stopped. Now you cannot procure the e-papers. Yes,
My lord,
have you undertaken some proceeding before you have discontinued the business?
yes, my lord, they have issued some emails to him, my lord, at from page 48. On multiple occasions, they have approached
Who?
the stockholding department to the petitioner, my lord. From page 48, these are the emails, my lord. Tried to contact the petitioner, my lord. But no response from the petitioner. Thereafter, it was regarding a huge anomalies in the e-stamp paper, my lord. So they got so many forged document there. And it's regarding, my lord, the license was issued in accordance to the agreement. There was an agreement basically between stockholding corporation and the petitioner, my lord, that was executed on 13 July 2023 at page 38. So this is a contractual obligation. So my humble prayer is that it doesn't lie. Number 1 point, my lord.
But there is no dispute.
And apparently the loss was on in the month of May, and they have filed this FIR in the month of July, my lord, after 2 months.
That we have seen.
And this representation, my lord, as they have annexed at page 21. So no
But Mr. Deka, without any proceeding, can you discontinue? It is affecting his rights.
My lord,
You adopt a
the
procedure.
proceeding we have followed. Basically, we have issued some emails, my lord, to him, but he didn't appear.
Thereafter, what did you take? Did you say that he did not appear? We proceed ex parte, make an inquiry and cancel. See, there may be a case where a person may opt not to cooperate. That will not make you powerless. You can still proceed ex parte.
Yes, my lord, her case is basically she has filed a representation. Let her file a more fresh representation. We'll consider, my lord.
But till then, without any action, discernible action to stop, you may have good reasons to cancel. We are not on that.
Yes.
But the reasons, the powers which you have exercised has to be done in accordance with law. Give her an opportunity.
I understand.
Even if after opportunity she doesn't come forward, you proceed ex parte, no problem.
Yes.
But number one, number two, if she comes, you have a proceeding.
Yes.
Then you at least give her an opportunity to explain, you take action. If the charges are, if she is found to be in fault. But without that.
So basically by these emails, they have.
Well, he did not receive emails.
No, that
He's no longer with them.
No, emails is not connected to being with them or not. These are factual matters. You might have received, you might not have received. We will not go into that. But now you are before this court. Mr. Deka is making a statement that they are trying to reach out to you. Now you issue a notice to her.
My lord.
If you intend to discontinue, you have to issue a notice and let complete the proceeding. Or you can file a representation, submit a representation. Consider that by giving her an opportunity.
Yes.
In the semblance of in the substantially, it will be in the nature of an inquiry. Give her an opportunity. Okay. Considering the facts and circumstances involved and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the admission stage. Please have your seat. As per the facts projected, the petitioner is running the business of a stamp vendor since the year 2018 in the office of the Deputy Commissioner, Nagaon, with license number so and so, 8 of 2018, dated 29/8/2018, full stop. The said license was renewed on 26/7/2023, and at that stage, there was a shift from the manual to e-mode, full stop. The petitioner had also accordingly made the necessary changes and was carrying out the business in the E format, full stop. However, on 6/5/2025, the petitioner had lost blank E stamp papers along with other belongings, for which an Ajahar was lodged on 9/7/2025, full stop. However, the account of the petitioner has not been allowed to be operated in spite of the application made by the petitioner on 19/7/2025, full stop. It is the case of the petitioner that his account has been illegally suspended by the authorities, through which he was running the business of sale of e-stamp, full stop. Para. I have heard Ms. K. Devi, learned counsel for the petitioner. I have also heard Sri B.M. Deka, learned counsel for the contesting response number 4. Full stop. Ms. Udas, learned state counsel, is present for the official respondents. Para. Ms. Devi, the learned counsel for the petitioner, has submitted that there was no blemish in the business run by her, which on the strength of the license issued in the year 2018. Full stop. She has also submitted that there was due diligence exercised by the petitioner towards the loss of blank e-stamp papers, for which FIR was lodged on 9/7/2025, full stop. The delay in lodging the FIR has also been explained by the learned counsel. Full stop. It is submitted that the suspension of the account has been done without any notice and without following any procedure, and the petitioner has been put to grave prejudice and hardships. Para. On the other hand, Sri Deka, the learned counsel for the respondent number 4, has submitted that there were many anomalies in the business of the petitioner after the shift made to e-mode, full stop. He has also raised the objection on the maintainability of the writ petition, as the parties are governed by an agreement, and therefore a writ petition would not lie, full stop. He has also on the facts, the learned counsel for the respondent number 4 has submitted that several attempts were made to reach out to the petitioner, for which emails were issued which were not responded, full stop. He has submitted that under those facts and circumstances, no interference may be made by this court. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Para. It is not in dispute that pursuant to a license issued in the year 2018 by the competent authority, the petitioner was running the business of stamp vendor, full stop. The dispute had arisen from an incident when the petitioner had allegedly lost certain blank e-stamp papers on 6/5/2025, for which the FIR was lodged on 9/7/2025, full stop. Though it appears that there was no promptitude in lodging the FIR, the learned counsel has given certain explanation, full stop. On the aspect that several emails have been issued to the petitioner as contended by the learned counsel for the respondent number 4, comma. The petitioner has replied that no such emails were received by him, full stop. Though the aforesaid aspect would be within the realm of disputed questions of fact, comma, it transpires that no procedure as such was adopted for discontinuing the account / suspension of the account of the petitioner, full stop. Para. Any action taken by the authorities would, having adverse civil consequences, would necessarily require an adequate opportunity to be granted and a proceeding be held in accordance with law, full stop. In the instant case, comma, it however appears that the petitioner had submitted an application on 19/7/2025, which is yet to be considered, full stop. Para. Be that as it may, comma, this court is of the opinion that interest of justice would be served if the petitioner is directed to submit a fresh representation, putting on record all the grounds which, if done within a period of 15 days, be considered by the respondent number 4, full stop. It is needless to state that in such consideration, comma, the petitioner is required to be given a hearing, and the respondent number 4 would take an appropriate decision on the matter strictly in accordance with law, full stop. The decision taken is required to be communicated to the petitioner in writing. UDAS State Council and Satyajit Datta for Standing Council Revenue. Okay, okay. Tar mazot likhiba, ha? Uporo. Yeah, we have given, because this may not have all the aspects. You take all the grounds, okay? At this stage, tar uporo likhiba. Sri Datta, the learned Standing Council Revenue Department has clarified that the representation is required to be presented to the District Commissioner Hojai, Nagaon, who in turn would forward the same to the DLR, and ultimately the DLR would forward the same to the respondent number 4, full stop. The proceeding and the opportunity of hearing is required to be given by the respondent number 4, which is the decision-making authority.
Lordship, for item number 16, kindly change the date, any other date than
16, 16, did you mention it right now, madam? What date did we fix? We said 10th. Okay, 14th? 14th.
I have produced the affidavit of opposition from filed by the government as well as private respondent. I will be allowed to procure the document of Manual of Procurement Goods 2024, Ministry of Finance Department of Expenditure, that has silent in this affidavit. Let this honorable government fix a place date. I will procure us.
Dr. B.N. Gogoi prays for some time to obtain further instructions, more further instruction on the
Tuesday.
No, on what aspect?
On the Manual of Procurement of Goods 2024.
On the aspect of Manual on Procurement of Goods 2026. 2024. Full stop. Also heard Sri H. Gupta learned CGC and Sri Alam for 5. Who's 5? Who is five? Private respondent? Oh, five. Para? In the interest of justice, matter is adjourned to be listed on 12th. Next Wednesday.
Inspection of scores for matter related to the regarding the land compensation without proper evaluation of the land as well as proper compensation versus cash, if you can say what in my hand.
Yes, you're for whom?
And for respondent number 5,
Who is five?
this is a construction company which has been allotted the work.
Who will pay, make the railways? Who's for the railways? Mr. Gupta? Where is Mr. Gupta? He was here. Names reflected. Mr. Hawk? Kaustubh Gogoi. Where is Mr. Gogoi? Otherwise, he is very. After a while.
For the last order, my lord, I mean, women who have sought for by the department, my lord. That letter is there and we have met and we have supplied all the required documents.
We have written, but we have instructed, they have to come to time. দিলে না জমা দিলে কালকে জমা দিলে জুয়াকালে জমা দিলে জুয়াকালে জমা দিছে ও ভেরিফাই করিছে ওকে
You need time, madam.
instruction because they have stated that yesterday those has been verified. Do not know what.
Yesterday?
They have asked for the document.
Yesterday had given it.
And
Okay.
they informed us yesterday only, they have verified.
So I need to.
Okay. Sri J.I. Barbuya, learned counsel for the petitioner, has submitted that pursuant to the orders passed in these proceedings, comma, the petitioner has furnished all the documents and as per instructions received, comma, those have been verified only yesterday. Full stop. Para. Miss Udas, Learned State Council, prays for some time to enable her to obtain the updated instructions. Para. List on, we'll have it on Wednesday next. Okay, 12th. 12/8.
Milo.
But he is, my lord, already verified with now.
Next.
We do not have that. Same Milo. Maybe.
Well, same 12.
Up to date Milo.
Next to Likiba, list along with WPC 300 of 2025 on 12th. Okay.
27th, I mean. On my lord, not Wednesday, my lord.
Oh, 14th? 14th, madam, 14th, Friday. Yes, Mr. Gogoi.
Independent autonomous.
Huh?
The econ is also independent and autonomous.
You are for the party. So your role will be there.
Their role is there. We have no role.
We have tried to deposit the approved compensation amount, the account of the beneficiary, but we have no right to determine the acquisition.
Who will determine?
That will be the same government of the.
But have you deposited the?
No, they have refused. Thereafter,
Who has refused?
the beneficiaries.
You have refused.
What the details they have.
Have you filed the affidavit?
No, Lordship,
You filed the affidavit. Put this on record. Put this on record. Heard Sri ABT Hawk, Learned Counsel for the petitioners. Also heard Sri K. Gogoi. Oh no, also heard Miss U. Das, Learned State Council. Sri K. Gogoi, Learned CGC appearing for the railways. And Sri
for 5.
T. Mazumdar, Learned Council for the response number 5. Full stop. Sri Mazumdar, the Learned Council has submitted. No, at the outset, the Learned CGC has submitted that response number 5 is an independent organization under which the work has been completed. Full stop. Para. At this stage, Sri Mazumdar, the Learned Council, representing the response number 5, has informed that the determined amount was attempted to be deposited to the furnished to the beneficiaries, which, however, has been refused. Full stop. He has also clarified that the determination of the compensation is not within the ambit of his client. Full stop. Para. Let affidavits be filed by the respondents, including the state respondents, which including the state respondent, including the state and the central government, which would be involved in the determination process. List on we'll have it on 7th of August, 7th of September.
Item 30.
One, two? Same. It was, this time about this. Right. 31. Mr. Das for whom? After a long time? 5, who is 5? Private respondent. Affidavit filed. Is it required? Not required. Required or not? Would you like to file affidavit or not? Not required, okay. Affidavit in opposition has been filed by the central government, which, however, is not tagged with the records. Para. What is your name, madam? Ms. R. Lakra, Learned Counsel for the petitioners. Praise for time to file rejoinder affidavit. Full stop. Sri A.J. Das, Learned Counsel for Respondent 5, has submitted that no affidavit is required to be filed by his client. Full stop. List this matter on 2nd of September, by which time the rejoinder affidavit may be filed by the petitioner. Oh, there are another respondent, okay. Miss S. Borpatro Gohai. Would you like to file affidavit? Okay. Who appears for respondent number 6 has submitted that affidavit in opposition would be filed by her client. For exchange of pleadings. Okay.
34.
Yes. Who's there? D. Chaudhary, Miss D. Chaudhary. K. Paul, who is Miss D. Chaudhary? Madam Bora, who is Miss D. Chaudhary?
Debo Lina.
You file affidavit. None appears for the petitioner on call. Whereas, yes, Madam Chaudhary.
Yes, Your Lordship. My instruction is that My plant has been communicated with the district health. Yes, J, junior engineer probably. Partial installment is already completed. Completion certificate also issued. And the later part, maybe 110 locations, just because of these are flood affected areas, Your Worship. That's why some delays caused. So further 2 months after vacation.
What do you say? Heard Miss D. Chaudhary, learned counsel for the petitioner, as well as Miss A. Bora, learned standing counsel, Health Department, NHM. Full stop. Both the learned counsel has submitted that due to the prevailing situation, has submitted that taking into account the prevailing situation of floods, there has been some disruption in the work, and therefore the matter may be adjourned to be taken up after 2 months. Full stop, para. In view of the aforesaid joint prayer need, the matter is adjourned to be listed on 30th of September. 30.
125.
What is this? Have you filed? No.
Milords, we need some more time, but in this matter, it's the whole thing is hit by the paragraph 14 of Tamsir Ali, Milords. There's a statutory period of there's a ruling. Through this ruling, 3-year period was granted. Within this 3-year period, if the claims are being raised, then it falls within the timeline. However, after this 3-year period, Milords, such
These works are of which year?
2020, Milords. That's where the last there is a page 25 of the writ petition, Milords. It follows the completion date as well. Except all serial number 10, Milords, the work order that has completed on 2020. Other than that, all on 2020, all on 2014. Even if it's on 2020, Milords, it's hit by the paragraph, Milords. That's what's going to be on.
Maintain this writ petition. How do you maintain this writ petition?
Contractor of the partner, each.
No, that we have understood, but how do you maintain this? Full bench. Admittedly, your works are of 2014. One is of 20. Even if it is 20, Tamsir Ali is very clear. He endorsed the principles laid down in the earlier Janata Pathak.
That's on both grounds. There's neither admission plus the timeline, Milords.
It is not maintainable. How is it maintainable?
That's what's going to be our stand on the affidavit as well.
You file the affidavit. Since notice has been issued, you file the affidavit. After the affidavit, we'll dismiss this. Okay. What is your name? Your name? S.M. Nath. Heard Sri S.M. Nath, learned S.N. Nath, learned counsel for the petitioner, who has submitted that affidavit in opposition was required to be filed. Para. Sri S. Sharma, learned counsel representing the PHE department, has prayed for some time to file the affidavit. He has, however, submitted that the writ petition is clearly not maintainable in view of the guidelines and principles laid down by the Honorable Full Bench in the case of Tamsir Ali versus so-and-so. He has submitted that apart from the aspect that there is no admission of the liability by the chief engineer, the works are of 2014 and one work is of 2020, which are all beyond the period of 3 years as laid down by the Honorable Full Bench. Full stop. Para. Be that as it may, let the affidavit be filed, whereafter these aspects would be considered. List on When? 26th? 26th.
Oblige,
You
my
file it before that.
oblige, my lord.
Short affidavit will do. Okay.
Oblige.
26/8. 26 तारीख.
I gave 26.
Application was supposed to file it.
And Mr. Chakraborty for?
We have, I'm for respondent number 8.
Filed.
We have filed, ma'am.
What is the matter about? What is the matter about? Huh? Denial of connection. You are a tenant.
No, I'm the owner of the.
Who is Mr. Chakraborty?
He claims to be owner of the land. In fact, there is a decree in my favor.
He also claims to be the owner.
My case is that, my lord, that particular land where I'm seeking connection is under the number 690. 690.
690 is a vacant plot of land.
That is what.
Why do you need electricity in a vacant plot of land?
No, no.
And 690 is not the subject matter of the decree.
No, this is a subject matter.
690 is subject matter of decree. He has got a decree in his own land. There is a 3-storied building. He is having a connection there.
There are two plots of land.
There is no confusion, my lord.
That is his contention. Otherwise, my lord, I am already having a plot of land where I have a 3-story building.
Yes.
That is not beyond denial.
That is the subject matter of the decree.
No,
No.
no, this is, it's another plot. And the problem is the authorities, judicial authorities, basically it's because of the circle office. They say that this is the land. In fact, during the suit, an Amin commissioner was appointed, and in fact, there was a report of the DLR. They came to a conclusion that this is a different plot of land, that is a different plot. Now the circle officer, he is sitting on top of the reports of the DLR. That is the case.
And what do you say, Mr. Chakraborty?
But admittedly, he is saying that he has one plot of land. Now, I have given a photograph, lordship. Let him clarify. We are prepared to exchange it also. Which is his land? If he is agreeable to that, my lord, there is limit of misleading, my lord. Lordship, kindly see 103 of my affidavit. There is a limit of abusing the process of court.
103. 103.
103, my lord. Let him clarify, my lord, which is his land and which one.
103, yes.
There is a 3-storied building, my lord.
On the left side.
No, my lord.
Left side.
No, there is a colored photo.
Yes, there are two buildings.
Yellow color. This
Yellow, left building.
Left side.
Yes.
Yes, madam. I'm sorry.
Yes.
3-storied building. This is 690.
690, okay.
And he has taken decree regarding this. His own plot of land, he has taken a decree.
Okay.
No dispute, my lord. I say that this is his land.
Okay.
Next page, lordship, kindly see.
Yes. Yes. 104.
104. This is my plot of land. This is a vacant plot of land.
Entire.
And there is a tin house, my lord.
Yes.
There is a partition also.
Okay.
This is my plot of
The
land.
center plot or entire?
No, entire. This.
Why this temporary fencing in between?
Yes. This temporary fencing is there. That plot is my land. That is 698.
Okay.
These are undisputed facts.
Okay.
Now he made here I had an electricity connection that he got disconnected on a particular day, and the same day he made an application there. And after going through everything, all report, they have said, ASPDC said that this is not your plot of land, we are rejecting. That is the impugn order. Now let him clarify which is his plot of land. Here, 3-story building, he is already having one. And he has taken a decree of this land only. 690.
690 is pertaining to the building or pertaining to the vacant plot?
That is a different plot.
690, not the building.
Not the.
What is the DAG number of the building?
Part of having to.
No, you can have. What is the DAG number of the building?
Yes.
That I'll bring it on affidavit.
No, please let us see the decree. Let us see the land covered by DAG number 690. Is it a vacant plot of land?
Please that document find it page, it's at the page 25.
25.
25. Page 27.
Let Mr. Das file the affidavit. It will be clear.
That would be.
Mr. Das, okay. Heard Sri RJ Learned, heard Sri RJ Learned counsel for the petitioner. Full stop. While the private respondent number 5.
Eight.
Represented by Sri B. Chakraborty has filed the affidavit, Sri P. Das, Learned Counsel, representing the APDCL, has submitted that the affidavit would be filed shortly, and in fact, he has furnished a copy of the affidavit to Sri D in the court today itself, in the court. First of para, let such affidavit be filed and tagged with the records, and the matter be listed on
Any hearing day, my lord?
on Tuesday next.
The meeting will allow to file affidavit reply, because in case the law.
Okay. Then let us have it on Friday. You make a submission. If you require time to file reply or Monday, then we'll grant you time. List on this will be on 10th. No, only for the purpose. With 10th, we are not going to go for disposal. Even if it's ready, then we'll have another date. Okay, 10th. By which time Sri D would obtain the instructions if any rejoinder affidavit would be required. Sri R. Talukdar, Learned State Council, is present for the state respondents, who has informed that affidavit has been filed. What is your stand? Your stand?
Land grading decree has been passed. That is the land covered by that number 690 law.
Yes.
And that is different. Which is different land wherein the electricity connection was applied for. This is that 690. It's different.
There is a report.
If you apply for 698, which is not your land, how do you expect the
There is a decree in 690 law.
690 will say 690 you have 2 more connections.
No.
We'll have that.
Yes.
690, how many connections you want, you say will allow. But not for 698, somebody else's land.
Photocopies of the bills are already there.
But if 698 the land connection is given, it will be given in the name of the person who owns 698, and bills will have to be paid by you. Very clear. Okay.
This matter I am made by senior counsel, Mr. P. He was here. For 2 moments he was going to attend the PC, my lord, before the conference. Can it be taken after a while? No. Item 39. The private respondent has entered different lawsuit.
I have filed my affidavit, but TCR was called for.
I see. Would you like to file affidavit? File affidavit already.
Affidavit.
Then we'll have a reminder for the trial court tribunal's record. Heard Sri S. Sandanu Chakraborty, Learned Counsel for the petitioner. Full stop. Also heard Sri K.M. Haloi, Learned Counsel, who has entered appearance on behalf of the respondent number 2 and has also filed affidavit in opposition on 24/6/2026. Full stop. However, it is noticed that though records of the learned tribunal were called for by the order dated 25/2026, the records are yet to be received. Full stop. Registry to give immediate reminder for requisitioning the record. Full stop. List immediately after receipt of such records.
The labor court guarding, not tribunal.
Records of tribunal, no, records of the learned labor court.
Labor court guarding. Much.
42.
Abdul Salam. Yes, I see is the party. Where is Mr. Smith? This is item number.
Lordship may kindly take after some time. I'll inform him.
His name is shown,
I'll
Mr. Day, after a while.
I'll inform you.
Okay.
Was asked to obtain introduction regarding tendency of. Yes. 44 and 45, my lord. Both is case 44 and 45, I have a small instruction, my lord. What happened in this case, both these measures, my lord. IMDT case was registered. Then thereafter, my lord, after the honorable apex court judgment in Subarnabha Sunan, it was re-registered at FT case, both the case.
Correct.
But thereafter records are not traced out, my lord. It could not be traced out.
What can be done?
Where about the record is not found. So at this stage, my lord, as the cases are there, the SP may make an inquiry, fresh inquiry on the basis of C, because the voter is there. Otherwise, his name will not be removed. Let the SP make a fresh inquiry on the basis of both this in collected to both these cases, my lord. In the same case number, and if there is anything, it may refer to the tribunal.
What do you say, Mr. Taludar?
Yes, my lord. But my only apprehension is that if fresh case is referred and later on the. Yes, in the same case, number, in the earlier case itself. That may not be done.
No, see, Mr. Taludar, your defense would be the same.
Yes.
Whether it is the earlier reference or a fresh reference.
Yes.
See, you have to see a reference is only with one word. Reference doesn't contain any reason. Reference says that you have to show cause why you should not be declared a foreigner. On what basis you show that you are a citizen of India, it's up to you. You produce the best documents, best evidence. Okay.
No, what my learned friend is saying, my lord, there may be multiple numbers of cases.
No, that will make it clear.
Yes.
There can be only one reference.
This case only, man. Yes.
Okay.
Yes.
We pass a common order. Both are similar.
Yes, both are similar.
The issue in both these writ petitions being similar, the same are taken up for an analogous hearing and are disposed of by this common order. First up, the aforesaid approach of this court is also agreed to by the learned counsel for the respective parties. Full stop, para. The facts in brief is that the petitioner in the respective cases was marked D in the voters list of 2017, both 17, pertaining to 39 Joleswar LSC. Correct in both? 39 Joleswar LSC. Huh? In another is Khurmuza. No, yes. 39 of village Kharmuza, pertaining to 39 Joleswar LSC in the district of Gwalpara. Full stop. It is, however, the case of the petitioner that though there is a reference to an FT case, in spite of due diligence, no such case could be found in the concerned foreigners tribunal. Full stop. It is contended that in absence of the reference, prejudice was being suffered by the petitioner by marking of D against his name. Full stop. Para, I have heard Sri M.H. Taludar, learned counsel for the petitioners. I have also heard Sri J. Payang, learned standing counsel, Home and NRC Department, Sri A.I. Ali, learned standing counsel, Election Commission of India, Sri R. Taludar, learned state counsel. Full stop. Notice was issued in this case on 26/6/20 in these cases on 26/6/2026, pursuant to which Sri Payang, the learned standing counsel, has obtained instructions. Full stop. As per the said written instructions dated 4/8/2026, the case records have not been able to be traced out in the respective either in the office of the concerned superintendent of police boarder or in the concerned tribunal. Full stop. The learned standing council has, however, submitted that since, as a matter of fact, D was prefixed to the name of the petitioner, comma, a new reference can be initiated, which can be brought to a logical conclusion by the concerned tribunal. Full stop. Sri Sri Talukdar, no, the Sri, both Sri Ali, Standing Council, Election Commission of India, and Sri Talukdar, the Learned State Council, have endorsed the submissions and suggestion of Sri Payang, the Learned Standing Council. Para. Sri Talukdar, the Learned Council for the petitioners, has submitted that though on principle he would not oppose to the aforesaid suggestion, comma, he is apprehensive of the fact that if subsequently the papers of the original reference is found, comma, the same may cause prejudice to him, as the petitioner would have to face two proceedings. Full stop. Para. After considering the facts and circumstances, comma, the course of action suggested by the Learned Standing Council appears to be reasonable. Full stop. Both the writ petitions are accordingly disposed of by directing the concerned superintendent of police boarder, which district? Walpara, to initiate a fresh reference to the concerned foreigners tribunal, which would act in accordance with law and conclude the proceeding as per conclude the proceedings. Full stop. It is, however, made clear that even that in the event the documents of the earlier reference are found out, comma, the same are not required to be proceeded again, as the present reference, which has been directed to be instituted and which has been directed to be made, would cover the case of the petitioner. Both the writ petitions accordingly stands disposed of.
42 time being.
I'm sorry, Malot.
No problem. Yes.
We have received the instruction a week back, Malot. I'll file my affidavit in opposition. 2 weeks.
Heard Sri R.D. Learned Counsel for the petitioner. First, the notice was issued. Para. Notice was issued on 26/6/2026. Puts of para. Sri M. Smith, Learned Standing Council, ESIC, has submitted that instructions have been received, and he prays for some time to file the affidavit in opposition. Para. How much time?
2 weeks, Malot.
On request, matter is adjourned to be listed on 24th of, we give you adequate time, 24th of August,
Malot.
by which time the affidavit in opposition is required to be filed. Interim is there. Interim order passed earlier to continue till the next date of listing.
50 times supplementary list.
Non-payment of compensation.
We are awaiting the instructions.
Heard 3P Border Learned Counsel for the petitioner. Para. Ms. P. Thapa, Learned Counsel representing the PNRD department, has, however, submitted that instructions are awaited, and she accordingly prays for some time. Para. Okay. Ms. Udas, Learned State Council, has, however, submitted that she has received the instructions as per which some time would be required for verification. Para. Be that as it may, comma, matter is adjourned by 3 weeks to enable receipt of up-to-date updated instructions. Full stop. List on 28, 28 तारीख. 28, 8, 28, 8, 22, 8.
22.
No, not 22, 2, 8.
28.
28, 8.
28.
60 same at all.
Okay, same. 28 তারিখ।
Obliged.
টোয়েন্টি-এইট 28, 28 Friday. Item number?
What if the order is at page 14?
Mr. Bhuya have appeared.
Yes, sir.
Yes,
So we'll need to obtain our updated instructions regarding this conversation.
come for the first time after notice.
Yes, sir.
Yes.
What has happened actually is the petitioner was called for some negotiation. After the order was passed by this honorable court, he negotiated, that amount was also settled in the month of January 2026. Till now, that amount has also not been released.
Take instruction. Heard 3M, thus learned counsel for the petitioner, as well as 3M Bhuya, learned counsel appearing for.
It will be for the Public Works Department in this case. But the
You do not want to appear for PWD, you appear for a particular officer.
particular.
For who's the officer?
Prashivat.
You should have your brief at your hand, mister. For responder 1 and 2.
1 and 2. 1 and 2.
2, 3 also. No, all I think.
No, Lordship, only respondent 1.
1. For the respondent number 1, who prays for some time to obtain the instructions. Para, at this stage, Sri Das, the learned counsel for the petitioner, has submitted that after notice was issued, a negotiation was held in which an amount was settled in January 2026, which however is yet to be released. Full stop. Sri Bhuya, the learned counsel, prays for time to obtain specific instructions on this aspect. Para. Matter is accordingly adjourned to be listed on, we'll have it on 26th of August.
Also, one small clarification. Where two amounts to be paid in respect of one amount, there was a negotiation. Second, there is no negotiation.
Doesn't matter.
Okay.
47.
This case where I was supposed to file sensitive decline. File next week.
2 weeks will grant you on the prayer of Sri RJ, learned counsel for the petitioner. 2 weeks time is granted to enable him to file rejoinder affidavit. Miss R. Deka, learned counsel for the respondent number.
Both the respondents.
For the respondents is present. Para. List on 21st of August.
What has been settled, kind of. Lordship may kindly is to madam put paragraph number 2 and paragraph number 3, madam. But some other cases are also pending, madam. In those cases, the payments are not received, madam. Kindly please, kindly put this paragraph number 2.
Of the affidavit.
Page number 11, madam. Order. The order.
Paragraph
Number 2 and 3, madam.
2 and 3, yes, what are they?
There is a issue involved, madam. If you lost it, put this 2 paragraph, madam. It will help me in other cases, madam, in other content cases, madam. It's pending, madam.
No, if they have
We have complied with
complied, this can be closed.
Only the maybe answer, yeah.
What mention?
One from
No, these are the facts recorded in the order.
those only.
What should he say about this?
Other content cases.
Now, what recording we will make?
Madam.
No. See, if the order is complied with, we'll pass an order. If it is not complied, we'll keep on proceeding. There is no question of these are part of the already of the orders of 10/5/2024. You can utilize this. Heard Sri SP Das, learned counsel for the petitioner, as well as Sri S. Bora, learned counsel for the sole respondent. Full stop. By referring to the observations of this court in paragraphs 2 and 3 of the judgment dated 10/5/2024, comma, the learned counsel for the petitioner has submitted that during the pendency of this contempt petition, comma, the order has been complied with. Full stop. In view of the above, the contempt petition stands closed. It's a ghost.
Just yesterday we received instructions regarding this.
Complied or not?
Lordship, financial sanction has been sent to the government and it will be.
Heard Sri BJ Ghosh, learned counsel for the petitioner. Full stop. Also heard Sri M. Bhuya, as well as Sri D. Deka, learned counsel for the respondents. Para, Sri Bhuya, the learned counsel for the respondent number 2. For 1. One has submitted that as per the latest instructions dated 4/8/2026, comma, budgetary provision has been made in the current budget and the financial sanction proposal would be submitted to the government within this week. Full stop. In view of the aforesaid development, the matter is adjourned to be listed on 2nd of September. Full stop. On the next date, comma, the learned counsel for the respondents will obtain updated instructions. Let us see. Let us hope.
51.
Yes.
The order, your lordship will find relevant portion page 17.
Notice was issued. Yes, we have appeared.
That's for us, was 6 years. We'll file reply.
3. You file your. Okay.
4 and 5, I think same. Please supreme then. Fine.
Heard Sri H.K. Das, learned senior counsel for the petitioner.
They have to include the present income and inspectors not 4 years.
That's 1 of 4.
4 is not.
Full stop. In this case, notice was issued on 24/6/2026. Para. Sri K. Gogoi, learned counsel, and Sri R. Gogoi, learned counsel, has respectively entered appearance for the respondent numbers.
I'm for 6 and my brother is for 3 loss.
3, 6 and 3 respectively. Respectively, 6 and 3. Full stop. They have, however, informed that so far as the incumbent who has been added as respondent number 4 is concerned, comma, there is a change due to transfer. Full stop. While time is granted to the respondent numbers 3 and 6 to file affidavit, comma, Sri Das, the learned senior counsel, may take appropriate steps to impede the present incumbent holding the post of respondent number 4. Para. List on 2nd of September.
May please. As per the last order, direction was given to the petitioner to approach the district administration to retrieve his belongings. Accordingly, a meeting was held on 20th of July where he participated. As far as my knowledge goes, my lord, he has not yet retrieved it. And moreover, my lord,
Well, what was the outcome of the meeting? It
The
was,
outcome of-
he was permitted to take out the belongings.
yes, he was. He
Yes, that is a subsequent development. We are filing an IA alleging violation on the part of a private respondent who prevented us from retrieving the belongings.
You find the IA then.
And we filed that, with them file the
Now,
affidavit.
while Sri J. Bora, learned standing counsel, ATEPFO, has submitted that a meeting was held on the aspect of retrieving the personal belongings of the petitioner, comma, Sri N. Barua, learned counsel for the petitioner, has clarified that there were resistance in the aforesaid manner, in the said aspect, full stop. He has also submitted that in this regard, an interlocutory application would be filed, for which he prays for some time. Para? In that view of the matter, comma, let's such IA be filed if so advised, and the matter be listed immediately thereafter.
We have paid for listing on 21st of August.
Whenever you file the IA, it will be listed.
I'll be filing this soon as well.
Make a mention of the IA, we have said.
Apply.
Hearing us, because
Sir, is just on the way to the court.
on legs. Oh, you had done the research. We had heard this matter day before yesterday, I think.
Just on his way to the court.
On the fiscal interpretation on the fiscal matters. Last matter, Niketo. Kundu rhyming. Let us have the rhyming matter. Hmm?
My line senior is still starting the BC, my lord.
We'll have some other day then.
And can it be on Monday then?
Okay. Into Hirikora. On the prayer made on behalf of Sri K. N. Chaudhary, London Senior Council, matter is adjourned to be listed on Monday. 10th. And this matter, when do you want? Yes. Okay, that will have it on Monday. We'll have some other day if the council is not there. Tomorrow?
We here, but they have prepared a compilation of judgments. Can you please?
Oh, Gayan has come.
Lordship, he has come.
Is also coming, Sarab sir.
Yeah, it will have a file.
Then compliance thing will be the same. Or this, as it.
Yes.
Well, first of all, there is for lordship. During when judgment of the court. Page 151.
One 21.
115.
115.
5. Relevant part at page 120. Last 8 of 10 lines. The appellate having.
Paragraph 11.
11.
last 8 or 10 lines, you know.
Hmm.
The appellant having been found to be eligible for exemptions and refund of duty paid, denial of benefit of exemption and refund of the ground of delay in our considered opinion will cause grave injustice which cannot be permitted. Even otherwise, it is well settled law that none following the procedural requirement cannot deny the substantive benefit otherwise available to assist. Also, exemptions made with a beneficial object like growth of industry in region active liberally constitute and a narrow construction of prohibition with different object cannot be accepted. So this was in relation to the industrial policy and the excise exemption by which the notification was issued.
Okay.
We'll also kindly see the division made judgment of the Tripura High Court at page 184. Page 190. Paragraph 41. The power of limitation is not prescribed in the Act as discussed above. In respect of self-assessment returns under section 29 of the Act, and when the petitioner submitted his refund claim for each of the financial years in question on so and so, in addition to the provisions of the application within the 7-8 months of the end of the financial year, the respondent ought to have processed it, could not have rejected it. Not only that, the objection raised by the lender because of so and so, it was never made. But
You're reading paragraph 41.
41. Then 42 below.
Yes.
42 says below that not only the objections raised by the respondents highly related because prior to so and so it was never made, but it cannot be also be counted that since the substantial rights suffered on the section so and so of the Act to get a refund of that cannot be denied for non-compliance of the procedural provision, that is non-submission of the applying so and so. So in the policy and the scheme, there is no provision. I will also see the same judgment below page 195, para 67. Here
67.
in this era where the states are expected to do business friendly.
Hmm.
And there is much talk of the ease to do of doing business. It develops the respondents to eschew conduct of the above nature if it were to attract business investment in the state and make the state prosperous. This is only on the ground mirror, the technicalities do not come because it will frustrate the object of the policy as well as the scheme. I will also intend to produce certain judgments on the how the exemption notification etc. to constitute.
Yes.
Page 1
Of the compilation.
of compilation. No?
relevant part at page 37, at page 16, para 37.
Page 60, paragraph 16 or page 16, paragraph 37.
Right, page 16.
Yes.
The notification in question, however, are not exemption notification. They provide for set of adjustment tax. A dealer in terms of the 1981 Act must be taxed, but it may be granted exemption therefore in respect of the certain items of the of adjustment and set off therefore in relation to the particular products manufactured and new existing industry. The notification may be issued under section so and so in respect of one or more products or in respect of one or more units. However, whether a dealer could be entitled to the benefits of set off unit wise or not will depend on the language employed, keeping in view the object which the notification seeks to achieve. It will not be proper for the court of law to prescribe limitation or restrictions which there is none or vice versa. So when the scheme and the policy had not prescribed a limitation, the circular cannot prescribe a limitation and deny the benefit of the policy and the scheme. Also, can we see para 41 minutes? Page 17. The court judgment was dealing with a reverse situation. It accepted the principle of law that the notifications have to be interpreted, keeping in view the object and the object being to encourage investment and production. It was held that the legal interpretation which advances the object of the notification should be ascribed. The court further observed, thereafter again the observations of the court are there. Then para 52 at page 20. Court referred to a judgment of the Supreme Court,
Yes.
In so it was clearly held in dealing with the submission of the criminal notice that the decision of this court in so wherein this court held that the exemption should be construed, although the exemption clause in the notification may be construed liberally. In other words, eligibility criteria should be construed strictly, but a liberal approach should be adopted in construing the other conditions. We are here concerned with the case with the eligibility criteria. So far as the eligibility criteria are there in the policy and the scheme, they are to be construed strictly. But so far as the policy procedure part is there, that has to be construed liberally to advance the object. Lord's next can be case 22. Relevant part as page 28. 32. Paragraph 8.
Page 2022 is what?
32. Para 8.
2007 9 SCC. Oh, no. Oh.
Very good. I could pass the interim judgment entirely on the ground that operational guidelines being in the nature of the subordinate subdelegation, delegated legislation, the same was required to be in consonance with the IPR and by reason thereof no other or further conditions could have been close stipulated so as to prevail over the policy decision itself holding.
You were reading which paragraph?
Para 80. Page 32.
Yes. The High Court passed.
My lord.
The High Court passed the impugned judgment. Para 8.
My lord, the High Court passed the impugned judgment in the inter alia on the premise that the operational guidelines being in the nature of the subordinate subdelegated legislation, the same was required to be in consonance with the IPR and by reason thereof no other further condition would have been stipulated so as to prevail over the policy decision itself holding. Thereafter, you also may skip over and may come to my lord E at C. Page 33.
Yes.
The operational guidelines of the instructions were made for the administration of the incentives contained in the policy and not for the purpose of imposing any new stipulations and or conditions alien to the and or not in consonance with the passing of the 1992 policy. Such a stipulation cannot in law be read and allowed to operate since it would frustrate the very objective sought to be achieved by the 1992 policy declarations. Page 38, my lord. Paragraph 15. Furthermore, a well-settled principle of law that an commission notification must be liberally construed. See so and so, my lord. And thereafter, the said principle therefore applies in all forms in the present case. So far as the exemption notification is concerned, my lord, my submission for lawsuit that all settled principle that eligibility criteria that has to be considered strictly, but the procedural matters, a liberal meaning has to be given so as to achieve the object of the industrial policy as well as the below notifications. Lordship, can you see page 40?
Yes.
11 page 51, paragraph 29.
The GP ceramics.
Right.
Which paragraph?
Paragraph 29, yes. At page 51. It is now a well-established principle of law that whereas eligibility criteria laid down in the admission notification are required to be construed strictly, once it is found that the applicant satisfies the same, the admission notification should be construed liberally. Now, page 50, page 53, you'll also going to see the quotation from the earlier Supreme Court judgment.
Which one? Paragraph?
Paragraph 26 is a quotation from the CIT versus your paragraph 31 paragraph 31 you'll also see. The Supreme Court judgment is mentioned below. And from there, the paragraph 26 has been quoted, reproduced below at page 53.
Yes.
Even otherwise, the purpose of notification being to encourage increased production and to give benefit to the industries which have invested rupees so and so and more so in the state, whose production has thus increased, and interpretation must be given which would extend the benefit to such industries. Thereafter, paragraph 32, Miller. This is observation of the Supreme Court. We do not see any conflict in the ratio laid down in the aforesaid two decisions. The question of applying the principles of the strict or liberal interpretation will arise only when the plain meaning of the attached thereto is found to be absurd or anomalous. If a plain meaning given to the provision of the purpose of a consideration of whether the applicant had fulfilled the eligible criteria as laid down in the notification or not is found to be clear below. Clear purpose and object the notification seeks to achieve must be given effect to. Now, this is admitted, Miller, my friend also yesterday pointed out that for other periods, the petitioner was granted the interest subsidy. Meaning thereby, there is no dispute as regards the eligibility of the petitioner. I will also see page 55. Different part at page 65.
Yes.
Paragraph 25. 24. That notification is given a literary meaning because to the other principles of the tenets of interpretation or the statute.
This is which case? This is another case.
Lord, this is another case, Lord. This is Assistant Commissioner versus Amara. As a particular at page serial number 4.
Do you have a citation here online?
Mention is serial index, Lord. Serial number
No,
4.
no. Citation mentioned.
Mention at the index, Lord. Serial number 4.
Some VST is there. Other citation will be other citations. Assistant. Yes.
At page 65, paragraph 24. An exemption notification should be given a literally meaning because to the other principles or canons of the interpretation of the statute should be resorted to only in the event the same gives rise to anomaly or absurdity. The exemption notification must be construed having regard to the purpose and object it sought to achieve. The government sought for the increase in industrial development in the state. Such a benevolent act on the part of the state, unless there exists any statutory interdict, should be given full effect.
I will also see page 67.
Yes.
Look, it has been in GP ceramic, you know, if I pair 30 miller.
GP we have already read.
Right, so that has been reproduced miller again up to the state of Odisha miller. You know, in the state of Odisha versus Tata Sponge so and so.
Also, we have read this.
Para 31 miller in the right side, left side.
Yes, that Tata Sponge we have just read.
Yes, yes. The state of Odisha miller, they were also referred to. I think I given the judgment in the. We may skip over the subsequent part. I've given the judgment of state of Odisha also.
Yes, Tata Sponge.
I will just see page 70.
70.
70.
Kerala High Court.
Look, this is
Kerala High Court. 70 is Supreme Court. Okay. Supreme Court.
para 10, page 81.
Two 2011 to SCC.
Very good.
74. Commissioner of Customs.
In the index, not everything is mentioned, you know, since I write only serial number.
Yes, which paragraph?
So para 10, page 81. It is a settled law that the notification has to be read as a whole. If any of the conditions laid down in the notification is not fulfilled, the party is not entitled to the benefits of that notification. The rule regarding exemption is that exemption should be generally be strictly interpreted, but beneficial exemptions being their purpose is to encourage or promote promotion of the certain activity should be liberally interpreted. This exemption rule is not subject stated in the any particular judgment in so many words. In fact, majority of the judgment emphasize that exemptions are to be strictly interpreted, while some of them insist that exemption in the fiscal statutes are to be liberally interpreted, giving an apparent impression that they are contrary to each other. But this is only apparent. A close scrutiny will reveal that there is no real contradictions between among the judgments at all. The synthesis of the views is quite clearly that the general rule is strict interpretation, while specific rule in the case of the beneficial and promotional exemption is liberal interpretation. The two go very well with each other because they relate to the two different sets of the circumstances. Thereafter, para 11, they deal with the party notification. You may skip over. Our page 88, you know, intended to know the interpretation of taxing statutes. In fact, in this case, from the very beginning, all the judgments have been referred to, not giving the trouble of taxing the all earlier judgment,
Yes.
In fact, at para 17, at page 101,
for the first landmark judgment lot of A.D. Fernandez, where it was held that, the constitution bench of the court, while doing the interpretation of the relevant provisions of United so and so framed thereunder, ruled that in initiating a physical statute, it is not the spirit thereof, but the letter of law that has to be looked into. And that if a particular fact cannot be brought within the letter of the law, the subject is not to be made liable for the same. That emphasis has to be given as a strict letter of law and generally on the spirit of the statute.
And not merely.
Or,
And not merely.
or the substance of the law was highlighted. So, this was relating to the charging provision. Like, in this case, when we say about the eligibility in the policy and the scheme, there is no doubt it has to be strictly enforced. If one does not fulfill the eligibility criteria, he is out. But once he fulfills the eligibility criteria, then the Supreme Court has held, given two exceptions, that eligibility criteria is to be strictly interpreted, but the procedure thereof, that has to be liberally construed to achieve the object which was sought to be achieved by the policy and the scheme. In this case, all other judgments are referred to. I am not troubling your lordship, with all the judgments. Now, we also see in the interest subsidy itself is 122. 11 at page 131. Paragraph 23. Right, what you are studying below, the circular was issued that the 3% interest subsidy shall be available only on the loan which has been taken for the purpose of substantial expansion.
You're reading PDP stills. Para?
23. Page 131.
Yes.
In the instant case, subsidy scheme came to be issued to take care of the aspect relating to the investments interest subsidy in terms of the NEIPP 2007. The extent of admission subsidy in clause 5 of the subsidy scheme is understanding of the court is clear and ambiguous and not confusing and lacking of clarity as it sought to be projected in the affidavit. It is categorically stated therein that the industrial units with be given interest subsidy to the extent of 3% of the working capital advanced to them without any restriction or limitation for the same. Expression 3% of the increase in working capital loan actually drawn after undergoing substantial expansion over and above the average of the working capital loan availed by the industrial unit during the years just preceding the date of the commencement of the commercial production. After undertaking substantial expansion in the later circular dated so-and-so brings into entirely different parameters for the grant of the interest subsidy, and it is evident from the said letter circular itself that the same subsidy payment is sought to be restricted through such a restriction was not contemplated in the subsidy scheme, which is in turn was based on the NEIPP 2007. Subsidy scheme may not have the approval of the cabinet, but it cannot be said lost sight of the fact that subsidy scheme was issued to implement the policy decision taken pursuant to the cabinet approval and given and formulated under memorandum so and so. And on the basis of this, the circular which was there below, that was set aside. That is contained to the policy and the scheme which was central in interest subsidy. SLP was filed against the said judgment, my lord, and also find at page 134 that was dismissed. Thereafter, they filed a review petition against said judgment, which was also subsequently withdrawn. One of the cases they filed it, my lord, but that is a common judgment.
Yes.
I will also kindly see case 135. Para 25, page 155.
Page,
Page 155, my lord.
paragraph.
Paragraph 25.
Yes.
Where the Supreme Court referred to a 5-judge bench judgment of the Supreme Court. A recent 5-judge bench judgment was cited by so-and-so in the support of so-and-so. The 5-judge bench was set up as a 3-judge bench in so-and-so was doubted as the said judgment noticed that an ambiguity in the exemption provision must be interpreted in favor of the SSC, claiming that the benefit of the such exemption must be interpreted so and so. This court, after dealing with the number of judgments relating to the exemption provisions in tax statutes, ultimately concluded as follows. Number one, my lord, to sum up, we answer the reference holding as under. Exemption notification should be interpreted strictly and instead of providing, my lord,
The burden of
the burden
providing.
of proving applicability would be on the SSC to show that his case comes within the parameters of the exemption clause of the exemption notification. When there is ambiguity in the exemption notification, which is subject to the strict interpretation, the benefit of such ambiguity cannot be given, claimed by the subject SSC, and it must be interpreted in the favor of the revenue. The issue of so-and-so, which took the similar view in so-and-so, states overruled. Now we also see. It is noticed that the 5-judge bench judgment did not refer to the line of authority which made a distinction between the exemption notification generally and the exemption provision which have a beneficial purpose. We cannot agree with the so-and-so contention that the substantiation, the line of judgment such for the beneficial exemption has been done away with by this 5-judge bench judgment. It is well settled that a decision is confined to the authority only what is decided and not what will logically follow from it in so-and-so law. Thereafter, the court said, my lord, paragraph 27. This being the case, it is obvious that the beneficial purpose of the exemption contained in so-and-so must be given full effect. The line of the authority being applicable to the facts of each case being in line with the authority which deals with the beneficial legislation as opposed to the exemption as generally in the text statute. This being the case, a literal custom, a formalistic interpretation of the statute at hand is to be eschewed. We must first ask ourselves what is the object sought to be achieved by the provision and construe the statute in accord with such object, and on the assumption that if any ambiguity arises in such construction, the such ambiguity must be in favor of which is exempted. Consequently, for the so-and-so. So, the Supreme Court said the 5-judge bench judgment dealt with the exemption notification generally, and not the exemption notification which has been issued in pursuance to, my lord, a industrial policy, or you may say, my lord, any scheme for the promotion and development of the industrial unit. So the Supreme Court distinguished, my lord, between the execution notification generally given and one given for the promotion of industry and the development of the industrial area. One judgment, my lord, of this honorable court, the coordinate bench, at page 157. (183). Para 47. Whole paragraph.
Paragraph?
Para 47. (183), no, please.
Yes.
It is the opinion of the court that the interdepartmental communication dated so and so, as well as the operation guidelines dated so and so, cannot limit the petitioner entitlements in terms with the clause so and so of the notification dated so and so. So, my lord, the notification which was said, the court held that the interdepartmental communication as well as the guidelines cannot limit the scope of the notification which was issued. This was also in pursuance to the industrial policy resolution. My lord. My lord, in my humble submission, the subsidy scheme as well as the industrial policy have not laid down any period of limitation. The interdepartmental communication cannot prescribe any period of limitation, cannot go against the specific provision of the policy and the scheme. Secondly, my lord, the eligibility conditions, the criteria of the policy and the, my lord, the scheme have to be strictly construed, but the procedural requirement, that cannot take away the right of the petitioner to claim the subsidy, which was in the division bench judgment also. Jokai said the delay cannot take away the right of the person to claim the subsidy. Third, my learned friend pointed out that the division bench judgment of the Tripura High Court, in view of the various judgment of the Supreme Court as well as the judgments of the coordinate bench and the division bench of the judgment of the this honorable court, in my humble submission, and also the judgment of Tripura High Court itself, where they say that the limitation, if it not provided in the act, it cannot be by way of rules. Now, if it is not in the rules, these are the communication, how that can be a mandatory provision. So, in my humble submission, the Tripura High Court judgment, in fact, in my respectful submission, laid down the correct law, and thereby this honorable court may not, rely on the state judgment. State, the various Supreme Court judgments are there, as well as the coordinate bench judgment and the division bench judgment of this honorable court. So, the petitioner having submitted the claim within 1 year, and this honorable court having held in respect of the other scheme, which are also under the policy itself, wherein also the same type of circular was there for 2013 itself. If you looks into the circular, it is mentioned transport subsidy and all those things. Same circular was there. So when in respect to the same circular, this honorable court has already, decided the matter. In my humble submission, the same issue may be made applicable in the present case, and the petitioner's claim may be examined on merits without going into the point of limitation, and that may not be rejected. That is my humble submission.
Yes, madam.
Your Lordship. Page number 154 is the office memorandum, my lord.
Of the brief
2000, yes, my lord, of the, that is in my affidavit in opposition,
page.
page 144.
এটা হলো কোন কোডিয়া না পিছার দিব 144
Yes, and that is also in the petition also. This is my lord, Northeast Industrial and Investment Promotional Policy NEIPP in short 2007. Here, my lord, the government has approved a package of fiscal incentives and other concession for the Northeast region, namely the Northeast Industrial and Investment Promotion Policy 2007, effect from 1/4/2007, which inter alia envisaged the following. These are the clause of 2007 rules. Now, my lord, kindly come to that subsidy is 3% subsidy in page number 145, Roman 7, my lord. That clause is in Roman 7, page number 145, my lord. Interest subsidy. Instead, will be made available 3% working capital loan under NI.
is 145.
5.
This is Roman 8, not 7.
Roman 7, 8, sorry, my lord.
Yes.
That is regarding the issue, madam, 3% interest, 3% available 3% working capital loan under NEIPP, my lord. That is available under this scheme, my lord.
Yes.
Now, my lord, kindly come to page number 146, my lord. Next page, my lord.
146.
Yeah. Roman 15, my lord. Then the Northeast Industrial Development Financial Corporation will continue to act as a nodal agency for disburse the subsidies under NEIPP 2007. The new industrial policy number 2, then my lord, after 15, then come number 2, my lord. The new industrial policy under concession in the Northeast region announced the height so and so 99 will cease to operate with effect from 1/4/2000. The industrial unit will have commenced the commercial product on or before 31/3/2000 will continue to get the benefit and is under any IIP. The next is important, my lord. The government reserved the right to modify any part of the policy in public interest, my lord. Number 4, all concerned ministries, department of the government of the India are requested to amend their respective rules, notification act and issue necessary instructions for giving effect to this decision, my lord. This decision means, my lord, this is the object of the NEIPP scheme, my lord. Page number 147 to 150. This is the procedure under how can they claim, my lord? This is the procedure 147 to 154, my lord. It is the fact that there is a no time limit in the scheme, my lord, and that has come by page number by the circular, my lord. Circular dated 16 September 2013, page number 127 of the writ petition.
Which page?
Page number 127 of the writ petition, my lord.
127.
This is 16 September 2013. Timeline for handling the claims under the Northeast Industrial Investment Policy NEIPP 2007 and Transport Subsidy Scheme so and so Scheme 2010. I am directed to enclose here to PROCEED along with the timeline for handling the claim of the scheme under the Northeast Industrial Investment Promotion Policy 2007 and Transport Subsidy Scheme for Paid Subsidy Scheme for information and necessary instruction. And
Yes.
page number 128, that is the time limit, my lord, given by this circular, my lord. Industrial unit submit the claim on within 365 days, my lord. And in the note, my lord, in that case, page number 128, note 1, my lord, in the bracketed figure are expected timelines in the number of the days, my lord. My lord, this is not the this is not a contrary to the statute of, that is the scheme, my lord. Statutory scheme, that is 2007 NEIPP scheme, my lord. That is that only the expected timeline to claim that to submit the claim, my lord. And in this regard, I would like to point the my lord, of Supreme Court, my lord. More public control. Capacity. Nineteen 67 here, 1920.
Yeah, 1967.
1967.
One.
People. People. No, but yes. Why can't it yes? This is my lord, constitutional bench judgment, my lord. I will kindly come to page number 9, my lord, of this judgment. Page numbers are given below, my lord, not in.
Nine, yes.
We proceed to consider the next contention of Mr. N.C. Setterjee that in the absence of any statutory rule governing the promotion to selection grade post of the government cannot issue administrative instruction, and such administrative instruction cannot impose any restriction not found in the rule already framed. We are unable to accept this argument as correct. It is true that there is no specific provision in the rule laying down the principle of promotion to the junior or senior grade officer to the selection grade, but that does not mean that till statutory rules are framed in this behalf, the government cannot issue administrative instruction regarding the principle to be followed in the promotion of the officer concerned to select the grade post. It is true that government cannot amend and suppress the statutory rule by administering, but if the rules are silent or any particular point, government can fill up the gap and supplement the rules and issue the instruction not inconsistent with the rules already framed. But this by giving the time 365, that is not inconsistent with the rule. They're not inconsistent with the scheme, my lord. Though that is the silent ballot then regarding the time limit. It is silent ballot regarding the time limit. And my lord, in the learned senior counsel appointed of 2007-9 SCC paragraph number 11, page number 33, my lord. By by lord, by subsequently by bringing anything by the administrative or executive name, my lord, that should not be frustrate the statute, my lord. By giving this time law, that does not frustrate the statute, my lord. That is the NLPP scheme 2007. And nor it is the violation of Article 14 and 21, my lord. That is not the violation, my lord. No one is affected by giving this time limit, my lord. So that is my humble submission is that does not frustrate the statute, my lord. That is my humble submission, my lord. And my lord, and my lord, they submitted after not only after, not immediately after 360 days, they have submitted after 2 years of that, my lord. That is 2 years. It is permissible, but they submitted before after 2 years, my lord. That is reasonable, and this ground is the reasonable that they think that by the executive order, by the scheme, sorry, not scheme, by the circular, that they bring the time limit. That is the reasonable, that is not the unreasonable time limit, my lord. And they do not even they in 365 days, and they submitted their claim after 2 years of 1 year is my lord limitation period, and after 1 year, my lord. And my lord, in this regard, my lord, Kerala, Tripura High Court has rightly pointed out, my lord, in my affidavit in opposition, my lord. Tripura High Court has rightly pointed out in case number 169 of my affidavit in opposition, my lord. Case number 169 of my affidavit in opposition, my lord. The judgment of Tripura High Court.
We've seen the other day.
Yes, ma'am. Regarding the statutory interpretation, ma'am. In page number 169, para number 17, my lord.
Yes.
In this regard, it is relevant to refer to the maxim of contemporana esposito esto optima et forcima in leg. The maxim was considered in the case of Ultratech Cement Limited and another versus State of Rajasthan, other reported in 2021, 12 SCC 147. The maxim contemporana exposit est optima et fortissima in leg means that the best way to construct the document is to read, and it is would be have read when made. The principle of contemporana exposito, interpreting a statute or any other document by in reference to exposition it has received from the contemporary authority, can be invoked through the same, will not always be deceived on the question of construction. It is also held that even if the person who dealt with the act understood it is particular manner, that does not prevent the court in giving to the act in its true construction. Further, that interpretation to the statute received from the contemporary authority is not binding upon the court and may have to be disregarded if such interpretation is clearly wrong. In essence, so the doctrine of contemporary is applied as the guide of the interpretation of the statute and even document by referring to the exposition that the same has been received from the competent authority at the relevant point of time. This doctrine is also relatable to the doctrine of stare decisis, where under as exposition standing for long length of the time is considered to be a law of the settled in the applied as such. As regard as regard the contemporaneous construction places by the administrative and executive officer charged with the executing statute, the court lean in favor of attaching the considered weight to the same, but it cannot be laid down that the understand of the particular administrative and executing authority is always fait accompli and has to be applied even if erroneous. The true principle is just to the contrary, that is, if a construction placed by the contemporary authority is found to be clearly wrong or erroneous, the same deserve to be disregarded. In this regard, the principle of explaining above application of the magazine contemporary exposure by the apex court, this court is of the considered opinion that no material have been placed before us to demonstrate that the relevant provision, terms and condition of any IPP 2000 policy received by the notification
Revived.
Revived by the notification dated 22/11/2000 and guideline dated 27/5/2000, which laid down the timeline to be followed for claiming such benefit under the policy have under construed in the wrongful or erroneous manner, and the authority of the document, that is Union of India, to be discarded. As per OM dated 14/12/2016, in our case, OM is different, my lord. Paragraph number 3, all the terms and conditions regard coverage, neutrality and location and substantial expansion would continue to be same of the OM dated 1/4/2007. It is tried to observe that such exemption or incentive as a prolonged by the government are in nature of concession or incentive, which is privilege of the government. It is for the government to take the decision to grant such a privilege or not. It is also trial law that the exemption, concession or incentive can be withdrawn by the time. That is different, but the position of the law here, my lord, regarding the statute, the interpretation of the statute, my lord, that is explained in this paragraph, my lord. And my humble subpoena, when the statute give the power to amend, to modify the for the smooth functioning of the NEIPP scheme, my lord, in that case, my lord, by bringing the bringing the time limit by bringing the time limit by the circular, my lord, it is not wrong, my lord, and this is not against and it does not frustrate the NEIPP scheme, my lord, or any other provision of NEIPP scheme by giving this timeline, my lord. And even if the, my lord, the 365 and 365 is a reasonable time, my lord. This is not the time that he could not prepare the material document on all these things. 365 is the reasonable time, my lord. This is not unreasonable. And my lord, the state government has also filed their affidavit in opposition, my lord. I said more, but they in their case number 189, my lord. He submitted all other 3%, that is interest, my lord, subsidy in that. From paragraph number 5, from 1 to 8, my lord. Only one is time-barred, my lord. Only number 2 is time-barred, my lord. He had the knowledge of this time limit, my lord. That's why only one is time-barred, but the others they submitted within the time, my lord. And that has already been approved, my lord. They have the knowledge, they knew the time limit of 365 days in subsequent that is subsidy, my lord. And the first one is also, my lord. From 30/11/2012 to 31/3/2000 approved in the 23rd SLC. That also he submitted within the time, my lord. SLC, sorry. Dated 17/7/2008. It is SLC. 30/11/2021. That is my humble submission. That will not frustrate the NEIPP scheme by giving the timeline, and which is reasonable also. And he has submitted all others, interest subsidy within the time limit, only 1 month standard. And they have not explained the matter the why the delay. Like there was a delay of 2 years, 1 year's time. It's not explained.
Yes. Okay. Any short reply?
So 2-3 points. And when I refer to the provision in the policy, the government reserves the right to amend a scheme. There is no amendment of the policy in the scheme. The scheme is a capital investment subsidy, and that has not been amended, nor the policy has been amended.
Yes.
Secondly, my friend was relying on the judgment of the Supreme Court. The interpretation of the statutes which you also studied, asking for the physical statutes and the exemptions, and the labor and services are altogether different. And this was also seen. The Supreme Court explained that the 5 judges bench judgment also, and said that the exemption notifications, so far as the eligibility criteria is concerned, is to be strictly, but separately, the same is to be liberally construed. So far as the delay is concerned, the division bench judgment also is there, and as that has already laid down, the delay cannot be a ground for frustrating the claim of the. So far as the Tripura High Court judgment is concerned, the Tripura High Court judgment, Tripura High Court not taken into consideration any judgment of the Supreme Court on the interpretation of the fiscal statutes as well as the exemption notification for the purpose, objective of the industrialization and development of the industrial units. It only says that it is mandatory. My London friend is also saying it is mandatory. I will also mechanically see the page number of the affidavit. If this is the stand of the state, the union, this is mandatory.
Page
189.
189
My lord.
of?
Of the affidavit of position of the state.
Yes.
Where the dates were mentioned.
Yes.
Now, if it is mandatory, then the circular also prescribes the period for disbursement of the interest subsidy. That is also 365 days after receipt of the claim. So you also see the item number 1, the date.
Yes.
For the period 2012-13, it was approved in 2018. So 12-13, it has to be submitted within 14. I think it is 90 days or something for passing of the SLC and 365 days for disbursement. It was passed after 5 years, 4 years. Now, if it is mandatory, then the petitioner will become entitled to the interest on the delay which has occurred in disbursement of the interest subsidy. It was approved in 2018 and disbursed. You'll also find that I will find out that after 2 years, 3 years, you'll also is coming across regularly the cases where we come up that our cases are pending and they are not being considered. If you also looks into all the dates, they are all beyond the timeline which is prescribed by the circular. Now, if the timeline are mandatory, it cannot be one-sided. It cannot be only for the persons, the industrial units. It is also for the department also, it will be mandatory. And if they are not adhering to that time limits, and if the contention of the union is that it is mandatory, then my lord, in my humble submission, the petitioner will be entitled to the interest from the delay on the basis of the circular to the date of the payment. But I'm not making a submission because in my humble submission, it is not mandatory. You'll also find in the last part, it says the guidelines, and it is only for the purpose of administrative exigencies, my lord. And in the bottom, it is mentioned expected. If it becomes mandatory, my lord, the question of expected does not arise.
Yes.
And the Tripura High Court itself has held that by way of rules, you cannot provide a period of limitation when it is not there in the Act. Now, this is by way of a circular. If by rules you cannot provide limitation period, how by way of circular you can provide for a limitation period? There are two judgments if we just read together, the first judgment as well as the second judgment. Then the Tripura High Court itself has said that no time limit can be prescribed by way of rules which is not there in the Act. Then how time limit can be prescribed in the by way of circular which is not there in the policy and the scheme? So my humble submission, my lord, the question of going to the Tripura High Court would have arisen, and when the single bench judgment, the SLP has already been dismissed. The review application has been withdrawn. And following that, 3 judgments of this honorable court, coordinate bench judgments are there, where my lord, civil law has been let down. In my humble submission, my lord, the petitioner claim should be considered, and that will agree around the purpose for which the industrial policy in the scheme was framed, and not to frustrate it.
Okay, we'll consider.
Yeah.
Okay. Heard. Dr. A. Saraf, assisted by Sri A. Kaushik. Also heard Miss A. Gayan,
Also, my lord, my name was PK Bora also.
PK Bora, Yoshin PK Bora, A. Gayan, London CDC, as well as Miss U. Das, London State Council. Hearing is concluded. Judgment is reserved.
The last entire list is over by 12:30 minutes.
Hmm.
12:45 minutes.
One matter was left out. Mr. Ken Chaudhary could not.
Otherwise, entire list for last 4 days I'm watching, that full list is over. Value of life.